but circumstances don't allow me to do that.
It will come up day after tomorrow, your application for early hearing, right?
With your lordship.
Where is that? You,
I've already filed it, Your Lordship.
so memo, this also. What? But where is his case number and all that? Where do you, how do we get it? You are
I will file in.
16, 14 of 17.
Yes, Your Lordship.
You should give it in writing, no? We don't know what is the number. Yes,
I'll
1 minute. That's it. Day after tomorrow it will come up. Application for early hearing, we will fix a date.
Subject to your lordship's kindly, my lord. This is a expedite hearing petition has been filed, my lord, with respect to the TET notification where the Honorable Supreme TET notification, teacher
Notification.
teacher eligibility test. My lord, the Honorable Supreme Court has already passed orders in the matter. My lord, your lordships have deferred the matter till the orders of the Honorable Supreme Court. I filed the IA along with the orders of the Honorable Supreme Court, my lord. It can
Only one case.
my lord, two, yes,
One case.
one case.
Day after.
My lord, subject to your lordship's kindly, my lord. One more IA is there. My lord, this is a case where your judicial office.
Don't one per day doesn't apply. The one counsel stood up, he was saying 6 mention slips. So we said 1 per day or at the most 2 per day. Yes, please say. Yes.
Sorry. So judicial officer, my lord, who has been, writ petition has been filed challenging the minor penalty. My lord, the counter is filed. My lord, reply also is being filed, my lord. IA is filed, my lord, for expedite hearing of interlocutory application seeking for promotion. My lord, the minor penalty has already been worked out. But, my lord, she is not being considered for promotion. Interviews, my lord, are next week.
So you want final hearing, right? So we will fix a date on your IA day after tomorrow. The IA is to grant promotion. You said expedite
No,
hearing.
my lord. There is an interlocutory application already pending. I have filed an IA to expeditiously hear the IA, my lord.
That will come up.
Yes,
Yeah.
and great.
My lord.
We will decide then whether you are entitled to interim relief or not. Yes.
It's a contempt petition of the year 2018, my lords, where we.
You want the other side to go to jail immediately today, right?
No, my lords. My lords,
What do you first tell us what you have been doing for 5 years?
my lords, 50% of the land acquisition amount had been deposited to the petitioner. The remaining 50% has not been granted. So the matter pertains to 2018.
Right.
The petition.
No, what you want final hearing?
Yes, my lords.
Then move an application. You, what early hearing, what do they call here?
IA for fixing a date for early hearing. Not that we have been
Telling everyone, you can't be, you want to hear every time from the court, right? Each individual wish.
My apologies.
We are not, if you are taking chances by seeing whether it court grants me, it won't grant. Court is consistent. If you are trying to check our consistency, find out we are consistent. Immediately we told no, those two people you should have not mentioned.
My apologies, my lord. I just walked in. Deeply obliged.
So, Mr. Reddy,
My lord.
what is your this thing? It's all now. In 1 minute from now, we will pronounce, but we want to know what, according to you, what is the judgment?
Well, that is beyond.
No, any assessment,
Yes, sir.
lighter vein, Mr. Today.
Well, I was just telling my counsel for the state that there are some cases, all cases we do before your lordship, there are some cases which are mostly in personam, but some cases which have larger ramifications.
No, that's correct. What is, do you anticipate?
I'm just trying to dodge that question by this answer.
If it's inconvenient, don't answer.
When we write exam,
Ask.
at the end, we will be guessing what, how many marks I get.
No, it's just like, brother has said correctly, like we appear in the examination. And very often when we come home and we, with the question mark paper in hand, we calculate, oh, I've answered this. I must get 7 out of 10. Like that, we calculate our marks.
Well,
And in my entire life as a student, it has never matched. What my expectations have never matched the marks I secured. Only once where beyond expectation I got. Except once. Otherwise, it has always fallen short. So, we have read down rule 33B of the rules, and by saying that it does not, this thing we have held that the rule 33B, which provides reservation for local candidates is unconstitutional, and therefore instead of striking down, it has to be read down. And we have read it down to mean that this, it will not apply to permanent residents of state of Telangana, and the operative portion I will read. The petitioners claim themselves to be permanent resident of state of Telangana. It is therefore directed that in case petitioners produce residence certificate issued by competent authority of government of Telangana within 1 week from today, before the university, the petitioner shall be treated as local candidates. Needless to state that university shall consider the claim of the petitioners as local candidates as per their merit for admission to MBBS BDS courses for academic year 2023-24. The writ petitions are accordingly disposed of. Whatever remaining only, whatever what is the, you have to take a call. We have not said anything. They will be treated as local candidate. Obviously.
The first phase of counseling is already over. That is a reason.
In case you have any, this thing, Mr. Rao, seek a clarification. This order doesn't say so. They have appeared in first round.
We are only in the first.
Only 4 candidates appeared, but not all. Only 4 candidates appeared, not all.
Then you know what to do, right? If in case you want to know from us what to do, file an application.
Now, well,
Mr. Obvious, the answer is simple. If first 4 candidates have appeared in first round, you have to treat them as local candidate and give them admission. Remaining second round, that's the obvious. I mean, we need not tell you. But what we are afraid is of that, since Mr. Rao, you are appearing, then later on we are quoted as saying that the division bench advised me to do like this. They're not even advised. They say division bench directed us to do this.
But 7, 8 and
Please file an application in case you have any difficulty. File an application seeking clarification.
item 7, 8 and 9, these 3 cases, they did not even study here.
Mr. Rao, either to implement or SLP, routes are open. It will be available. I will instruct. We will instruct that it is made available on the website.
My lords, item,
Please go through the judgments. Please, just now we have pronounced. Please go through. Yes, next.
that's item 55 also the same, my lords. It is also
1 minute.
Item 55.
It
is
will be
also
called. It will be called. Mr.
Yes, my lord. Same way it is. We treated us.
deeply obliged. Now I can answer that question.
No, we need not ask him. That is. Now we will dodge that question. Answer your answer. The lighter vein, we said nothing. Please.
I'm so obliged.
Yes. Like 5 or 10 we have period. It must be exceeded. So this is that we this petition, this which should be already dismissed. The same thing here. We'll see. Heard on the question of admission, issue notice. No, heard Mark her presence heard. Notice on IA 1 of 23 and 2 of 23. So Vidyut Ombudsman is an order, madam. We have passed. Yes, enforcement.
We have 791 and 811 of 2000.
790.
791 of 2023 and 2811 of 20.
We have passed in order in this. Madam, WA 791 of 23, get the order. You will get it available online, right?
Yes. 791 and 811. Eight appeal. And 811. Both
Same order.
same matters
The
arising.
connected matter, my lords, it's posted on 11th, my lords.
No, there is an interim order passed. We want to be consistent, Mr.
Yes.
You are not telling us that this the order passed. So we ourselves are finding out.
The delay was controlled. In the IA2, my lords has directed me to file a counter, my lords, in the connected matter.
No, we stayed the order. We stayed the operation of the order, if I remember correctly.
Issue.
No, my lords, to best of my
811, I think we stayed it. Please check up. Amma, check again.
W855. Huh? Print out, madam.
Print out. We stayed. Sending out.
Yes, yes. Then where is the printout? You can't get it, madam. There is an interim order, mister. Don't time. You appeared,
I'm for the respondent too, my lords.
then you appeared in that case, right? There is an order of stay granted. Just mister. Not fair. What do you think? We don't remember or we will not find out? You are saying no stay is granted.
I apologize.
Right. Not fair. You are a young man. Be very this thing. Always be mindful of the statement made by you before the court, right? That's why we are telling you. And just like, I mean, don't develop this habit that if caught, say sorry. We are not sitting here to seek apologies from members of the bar. We are here. We want your assistance to effectively decide a case as you describe yourself an officer of the court, correct? Yes, but don't make incorrect statement. None for the appellant, record perused. Issue notice of IA, full stop. None appears for the appellant, record perused. This court by same order in item number 16 and 17 also. 15 you have written, madam. Same order type in 16 and 17. Notice on IA 1 of 23 and 2 of 23. Right? Both IAs notice. Same order. Yes.
Wait, please, my lords.
You appear
For the respondents, ma'am.
ready to take notice in anticipation.
I am appearing for respondents number 1 to 222, ma'am.
1 to
222.
222. And thereafter,
I'm appealing for a fellow
College.
medical college professor.
no, which respondent, Mr. This intra-court appeal has been marked their presence heard on the question of admission. This intra-court appeal is directed against a bi-party interim order dated 7/8/2023, by which the learned single judge has fixed the fee, has permitted the petitioners to pay fee in the manner indicated in the order. Full stop. Paragraph. We have heard learned counsel for the parties. We have heard learned counsel for the applicant in the writ petition, comma, in the petitioners who are students of which year?
This year, my lords.
Of the MBBS course. Which?
MBBS last year, ma'am. Postgraduate this year, 23-24 academic
Who
year.
are the students prosecuting or prosecuting their studies in PG course in MD medicine,
Medical and dental, my lords.
in
Postgraduate medical and dental courses.
postgraduate medical and dental courses had filed a writ petition seeking what relief?
My lord, I have challenged the
No, what relief?
set aside of impugned GOMS
Prayer,
number
prayer.
107.
Prayer.
Main prayer is set aside, my lords, and
Where is
suspended.
that prayer?
You will find the prayer at page number
114. Had filed a writ petition.
114. It starts, man. 114. It starts.
It's perfect. 187 is your prayer.
187, man. 187.
No, you must be, that is this thing, appearing on a advance notice, and so that's why he is spared. He is very happy that court is not asking me any question. You are, we are treating you to be,
Lordship.
yes. Students prosecuting the studies in postgraduate medical and dental courses. No. The petitioners in the delete, madam. The petitioners in the writ petition. The petitioners who are students prosecuting their postgraduate course in medical and dental courses had sought for the following relief. Had sought for quashment of GOMS number, quashment QUASH. They have not said so. Quashment of GOMS dated 28/7, GOMS number 107 dated 28/7/2023, issued by which respondent number?
First respondent.
No, who is one respondent number?
State of Telangana.
By state of Telangana. The petitioners by way of an interim order. So delete. What was done by this GOMS? Delete, madam. Interim order, delete. This prayer is this thing. Then the by said GOMS dated 28/7/23. What has been done, Mr.? The state government has fixed the fee for
the block
fee
period
payable by
2026.
students prosecuting postgraduate
Medical and dental courses.
medical and dental courses. Full stop. The petitioners in the writ petition had line below. Petitioners in the writ petition had prayed for the following interim relief. Quote, page 187, 188. Paragraph. The learned single judge, however, after hearing the parties, comma, by an ad interim order directed as follows, quote, interlocutory application is disposed of. Paragraph. This was 67 paragraph. This following direction 67. Take from 67. Right? They up to here, such refund. Paragraph. Learned counsel for the appellants submit that that in the garb of an interim order, the main relief itself cannot be delete. Learned counsel for the appellant submitted that the final relief cannot be granted by way of an ad interim order. It is further submitted that the learned single judge ought to have exercised a restraint in interfering with the impugned GO as it pertains to determination of fee structure. Fee structure. Alternatively, it is submitted that in case the learned single judge was of the opinion that the fee structure fixed by the state government was arbitrary, comma, it could have remitted the matter for consideration of a fee fixation committee. Full stop. Paragraph. In view of paragraph, the appeal is admitted for hearing. Notice on behalf of respondents number 1 to 222 is accepted by Mr.
Sandeep Reddy.
Reddy.
I've given the slip.
And what then 223 to GP 223 GP medical, then 224 Mr. Prabhakar Rao, learned counsel for 224, then fee regulatory committee for 225, then 231 and 232. Then issue notice to remaining respondents. In the meanwhile, operation and effect of learned counsel for respondents may file counter to IA number 2 of 23 if so advised within a period of 2 weeks. In the meanwhile, operation and effect of the impugned order shall remain in state.
My lord.
Till next date of hearing.
My lord, now.
Then beginning you write, madam, IA 1 of 23 for reasons assigned in the application duly supported by an affidavit. After appearance, right? Requirement of so and so is dispensed with, IA is allowed.
My lord, one request, my lord, not stay by. This is ongoing counseling, my lords. Fees has to be paid now. And the division bench judgment of this honorable court has not been followed, my lord. This honorable court has held.
No, but Mr. Tell us
Lordship.
that how by an interim order the court can fix the use of the jurisdiction of a fee fixation committee. That's the issue.
My lord, this is only an interim order, my lords. And for a minute, Lordship, may kindly hear me. There is a division bench order.
We will hear you, of course, because number one, that's why we ask you, you are not on caveat, right? You should have filed a caveat. You would have thought that they will not leave you. They will not leave you like this.
I'm already served with.
You are not caveat. You are only appearing on advance copies. File a counter to this.
My lord, to the question that your lordships posed of how can this honorable court fees, there is already an interim order passed by this honorable court, first division bench, my lords, same fees for a different block period. Your lordships will find that order at page number, for lordship kindly see.
Where is that order?
Lordship may kindly see page number.
No. Where is it referred to in the order impugned in this petition?
It is referred to, my lords, everywhere it has been. GOMS number 20.
20.
The learned single judge has lordship.
Fixed by Mr. This fee was fixed for previous years also by an interim order of
Same fees, my lord.
No. By an interim order of the court.
Yes, my lord.
No, this court, learned single judge of this court last year also fixed the fee.
Not single judge, my lord. Your lordship's first division bench has passed an interim order. Same.
Where is that?
Your lordship will find the interim order at page number. For a minute. 449 it starts, second volume, your lordship will get.
So, Mr. We will consider your appeal.
Very well, my lord.
Not still let them file counter.
Yes.
Let them file
My
counter.
lord, only submission, my lord.
They will not run away, right?
Very
Correct.
We are studying in those colleges, my lord, subject to outcome if your lordships.
Remaining amount you can furnish bank guarantee.
That is what I think the.
Bank guarantee is already there, my lords. We are already furnishing bank guarantee
No,
for the
they will
remaining
have
fee.
to pay 60% of the amount.
Lordship. My lordships, next 3 years, the petitioners are going to be in this college only, my lords. They are not running away.
You're not at flight,
They
risk.
have already issued a bond. Lordship.
Not at flight risk.
No, not at all. This is PG medical and dental courses, man.
We understand. And
My
see,
lord, similar
What did
direction
one-
was given at page 68, my lord. They have to give a bank guarantee.
admitted for hearing, right? Huh? Then don't meanwhile delete. Learned on the other end, his submission, right? On the other end, learned counsel for respondent submitted respondents 1 to 222
Yes, ma'am.
submitted that a division bench of this court, which order?
Your lordship will find the order it starts at 400 and.
No, date of order. Division bench of this court by an order dated 26th May 2022. 2020. Last year you said this is 20 petition.
Immediate before block period.
Passed in WP number 6799/2020 has done what? Has fixed
Yes, my lord.
the fee by an ad interim order.
Yes, my lord.
It is further submitted that the aforesaid interim order has been taken into account by the learned single judge while passing the impugned order. Paragraph. Let counter, if any, to IA number so and so, which IA number 2 of 23 be filed within a period of 2 weeks. List the aforesaid IA for consideration.
Lordship may
After
stay.
counter is filed.
Lordship is not staying there.
Not staying.
Very well. Oblige.
We will hear you.
Oblige.
We have deleted that portion.
Very
Meanwhile, delete.
I'm obliged.
We will hear you. Counter you
I'll
file.
file count.
Yes. Notice.
That regulation committee, that is the only job to your
Yes.
But my Hassan, I brought list of dates, brought 5 dates.
Yes.
Short list of
Dr.
dates, brought 5 dates.
Yes, but respondent rate petition. It's an appeal filed by the law.
Yes.
Brought on 10/6/2021, brought
Huh?
first date, brought 10/6/2021, brought communication was sent to the sub-register by the revenue department, enclosing a list of property properties, brought.
Hmm.
Brought, the petitioners filed a writ petition earlier, brought WP 8005 of 2023.
Hmm.
Wherein, brought, there was a direction to the registrar without going into the without a reference to the memo dated 10/6/2021 of the property list to receive, register and release, provided it is in compliance with the Stamps and Registration Act. But there is a circular issued by the registrar, Lord, by the IG and Stamps and Registration on 10/6/2019. See, for insisting of a no objection certificate, null conversion certificate, Lord. But after presentation of the document on 28/3/2023, a communication was sent by the sub-registrar to the collector. But wherein the RDO had reported to the sub-registrar saying that these fake certificates have been produced by the petitioners are fake. But that is, my lord.
You know, what is the grievance? You are still on facts. What is the grievance in the petition? Why did he file the petition?
But
And
for-
what single judge has
They
done?
want to register the document, my lord, belonging to the government, my lord, evacuate property. And they also want to register a bulk of land of
What is the registering authority?
36,179 square yards.
Huh?
36,179 square yards, my lord, they want to register, my lord,
Huh.
without producing the conversion certificate. They have produced the conversion certificate. On inquiry, it found out to be a fake document.
So, an inquiry, what happened?
The
What are-
RTO had communicated.
No, you tell us, in fact, it has been, I always wanted to see, my lord must be aware, my brother must be aware, that what are the guidelines, like statutory provision, which the registering authorities required to adhere to before registering a document?
Yes.
Which is it? Which provision, Mr.
22A.
22A of registration?
Registration Act.
Give Mr. What is 22A?
Registration Act.
But 22 speaks of prohibiting of certain government properties, my lord. But I am on the fact that there is a circular issued by the registrar IG, my lord, Samson registration, IG Samson registration. May I pass? May I pass on the circular memo, my lord, issued by the registrar? It's not fine.
No, pass on means you did not pass on to learned single judge.
It is referred to in the refusal order. It is referred to in the refusal order.
You did not pass it on to learned single judge,
Right.
right? This is stop this practice.
But once circular, it was referred to in the.
Then you will say that I had handed over to division bench did not take note
But
of in
it was-
SLP.
No, it was
Then
referred to and
SLP
extracted.
Supreme Court will say that go and file a review.
But referred to and extracted. But may I read the impugned order, my lord, in the writ petition first? At page 78.
No, this, Mr. This is 1 minute. Oh, we want to know the provision. 22A is not this thing prohibition. Where is what else is the registrar is required to do at the time of registration of a document? There are circumstances mentioned. 32.
32 is the procedure which the registrar has to follow
32. Yes.
when a document is presented.
32. Persons to present documents. It must be in the rules also. Rules, it must be there. What all he is required to consider. Inquiry 34 probably. 34.3, Mr. I was looking for 34.3. The registering officer thereupon shall inquire see Telangana rules and registration must be there.
Apart from this, my lord, section 69, that is power of the Inspector General, my lord. Section 69. To make
What
rules.
is your grievance, Mr.? You please tell us what is your grievance. He presented the document for registration.
Which is.
That was returned by the registering officer. He
Yes.
filed a writ petition. Then learned single judges held that the document should be registered.
That order has a finality.
No, it's only an interim order, not. It's only an interim order. The
No,
first round of petitions was only an
Yes,
interim
what
order.
order you have preferred an appeal?
That impugned
Which order
page-
you have preferred an appeal? Let's
At page 7, my lord. Page 7.
close the file. Tell us you have read the file, right?
Yes.
What is the order?
Order to receive
No,
and
just a minute.
register the document
He filed a document for registration.
along
That
with the
was-
converts.
That was returned by the registering officer, correct?
Yes.
Then he filed a petition. What has learned single judge held?
It was, he challenged the refusal.
Huh?
Directed that the document, well, it is the general core of a topic, it's not the same thing.
Huh?
My document is a GPA.
No. So what the learned single judge has done? It should be
It
registered.
has to be registered.
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 Huh? So why they have filed an appeal?
Against
No,
that,
no,
Not appeal.
no, Mr.
Not registering the document. when-
Probably we are not making ourselves clear. We are wanted to ask what is. No order to Mr.
Page 7 is the impugned order, my lord. Where repeat
You are
has been
unable
allowed.
to tell Mr. GP for revenue what the learned single judge has done.
Directed the-
He is saying provisional registration. You are saying no.
Directing the authorities to register the document, my lord.
Ah.
Page 12 is the impugned order.
Directed to process the document, registration and release.
Release the
So-
document. Basing upon the document.
No,
it has been-
So why according to you it should not be registered, number one?
It is a large extent of land which has not been converted. into the non-agricultural land. The certificate so produced found out to be a fake document. May I refer my lord's communication note of the.
That's it, right?
Yes,
So which provision of law says that it should be a converted land?
Rule 26, my lord.
That's what we are asking. Rule
Rule 26.
26.
Every document shall before the acceptance for registration be examined by the registering officer and to ensure that all the requirements prescribed in the act and in these rules have been complied with.
This is the provision.
Yes.
I was. Yes.
May I refer my lord's attention to page
1
7.
minute, 1. On what grounds you had rejected?
Page 70.
What grounds you had?
Page 73, my lord. Page 73.
Under Rule 26, first tell us what is not accompanying with this document.
My lord, where is this making power, my lord? 70.
Conversion.
Lord, section 69, my lord, the IG is.
You said, Mr. Rule 26.
Yes, my lord.
So where is this that conversion certificate should be there?
Conversion certificate is in the circular.
Rule 26.
Is in the circular which I have just passed on, Lord. By rule making power, Lord, the IG had issued a circular to all the registrars to insist upon the.
Mr. Just now, you referred to Rule 26 just now.
Yes, my lord.
And you are not reading it. We are looking at Rule 26. You are jumping to circular.
Yes. It has been presented in the proper office. Person entitled to present it.
No. Where does this rule provide that conversion certificate should
by
be?
virtue of a circular bill which I just now passed on, Lord.
It's not there in Rule 26.
No, my lord. It's only
Then why did you refer?
for the purpose of scope of inquiry. Scope of inquiry, my lord.
Use the court, right?
Scope of inquiry. The power of the registrar to inquire into before presentation.
So he can inquire into that. Nobody is saying that he can't.
Yes.
He has to conduct an inquiry. We will modify that order that he shall conduct an inquiry.
It has been refused. It has been already refused. Challenging the refusal order, writ petition has been filed. In spite of that, my lord, writ petition has been allowed. In spite of the submission, the document is a fake document.
But how can it be found fake or what?
The authority
See, Mr. Whether it's a fake document, I mean, the registrar decides whether any inquiry is conducted.
70, my lord, the concerned, the revenue department had issued a certificate to the sub-registrar. Page 70, may I read, my lord? Page 70. As per the revenue records, the land in survey number 297, extent of 19 acres 11 guntas, is classified as a vacant property. He then joint collector, without any authority, had issued allotment orders. The number referred to the fake
We'll hear it, Mr. We are issuing notice. Yes. Heard on the question of admission.
May I have one correction?
No, this is, you are on caveat.
As per our rules, the Sagalat continues the return.
So you are accepting notice.
Notice that opposing grant of interim order because there are.
We are not granting interim order, file objections. Heard on the question of admission notice. Notice on behalf of respondents is accepted by learned. Who is assisting you, Mr.? You are assisting him.
Yes, sir. Samir.
What's your name?
Samir.
Mohammed Samir. He prays for his granted 2 weeks time to enable him to file counter to IA. List thereafter. Initially, see, I have opened it. These people don't know it. Yes.
Pick up.
Questioning the action of the respondent for
in not considering the order of the report. RJWP number 2. Who is respondent number 4?
Respondent number 4 is the bank lordship. Already there is a common order passed in two WPs, 25174 of 18 and
No, no,
3412.
file contempt against them. How a fresh rate petition?
No, the lordship, the order was passed, the sale notice was been set aside.
What
The relevant portion.
which is the order under challenge in this petition?
No, we are not challenging the order. The order, the relevant portion, it is page 45. Lord. The common order.
They cannot cancel.
Option C is set aside, but in the meantime, sole certificate is registered. In favor of
Can you
the person on state, but they can, yeah, it is consequential to the.
You are what? You are a borrower.
Yes, Lordship. I have tendered my money also to Lordship. The letters are been filed before the court.
No, no. So what happens if sale certificate is cancelled? The property comes back to you.
Yeah, that was the direction given by the He is at liberty to invoke 13(2) again. At page 45, Lordship, the single judge has observed that in two writ petition.
No, DB, it is DB, not single jet.
Sir, please. Sorry, sir. I'm sorry.
They will see, right?
That's what. What is granted to them in this month?
So what? I mean, they are committing contempt of this order, right? Violation of.
We are
this-
not deleting from the list of the
So
registration.
then file contempt, Mr. How a fresh rate petition? I mean, we don't understand. You are saying that directions issued by division bench are not being complied with by a bank.
Sale certificate was issued
Bank
during
is
the
a party. One bank is a party, right, to this rate petition.
sale certificate was
One
issued.
minute, one lot. We want to understand page 30, page whatever order 45.
45.
The bank is a party to this proceeding.
Bank is a party to the proceeding.
If directions contained therein are not complied with by a party, what is the remedy? File a fresh petition, seek another set of direction.
Now, meanwhile, the registrar is entertaining some registrations which has been effected in favor of the respondent of file lordship. The unofficial respondent who is now holding a sales.
So you tell us that according to us, I mean that you should file a contempt petition against bank for not carrying out directions. How a fresh rate petition you are filing? Please answer this.
Because the observations which has been made, he is not initiating fresh action, he is not accepting the money, rather he is.
No, so therefore the grievance says that the bank is violating the directions contained in the WP.
Yes, Lordship.
Then if it is so, then file contempt.
Yes,
Simple.
Lordship. I may permitted
Yes.
to withdraw the writ petition. The liberty to
Learned
file.
counsel for the petitioner, after arguing the matter to some extent, seeks leave of this court to withdraw the writ petition with the liberty to file a contempt petition for non-compliance of the directions contained in the common order dated
This is 8/1/2020.
8/1/2020 passed in WP number 25174 and 34129 of 2018. Accordingly, the writ petition is dismissed as withdrawn with liberty as aforesaid.
I may be given liberty to
We have given you liberty to file contempt.
oblige.
Yes.
Deep love. May present.
The petitions before your lordship intends to admit the enrollment as an advocate. Agreed by the instructions issued by.
Array, Mr. Charges are confiscatory in nature. They are required to sell their property and pay fee for enrollment. This is the. What, Mr. You want to become an advocate and you don't have means to pay 57,000?
No, but it's made against the.
Every day.
About
In other petition, he knows that an argument was made before us that we are losing 1 crore per day because of our non-enrollment by the bar council. That petition we have heard. and here you are challenging 57,600. This quantum of amount, until unless you are able to demonstrate that it is confiscatory, no scope, it is beyond the scope of judicial review. Tell us. Challenging for the sake of it is very good.
It is.
No, it should be, you are ideally speaking, you may feel that I should be charged a token sum of ₹1 per day or one at this thing,
But
and
this-
they should welcome me. That's fine. But what is, seems to you reasonable?
Only with one submission, my lord.
Scope of judicial review is not this thing.
May I make one submission? A batch of writ petitions are pending before the Honorable Supreme Court in connection with this fees.
Fee. We will defer it. Which judgment?
Lord,
Which-
I'm passing on the writ petition and the transfer petition now.
From Kerala High Court.
Kerala, Maharashtra and Goa and Tamil Nadu also.
Mark the presence, learned counsel for the Bar Council is Telangana. What we have 100% is 7th September coming up.
100%.
Interim order.
Right, please, Your Honor.
Madam's interim order is, where is that 100% interim order? On or after 2/6/2000, Mr. Prabhakar, which case we have passed?
On 19th August, your lordship.
Huh?
94, item 94.
Order. They are listed today. We will pass the same interim order, correct?
Same order.
So, Madam, WP number, this is the order, right? That you can pass, right? You can type it just like this. Huh? Yes, 6/9/23. This same order.
May I request, my lord? My lord, the same facility, my lord. Yes,
No, you are appearing in which case?
27, my lord.
1 minute. We are at 22/23.
I'm sorry.
22 and 23, same order, right? I will give you just a minute, madam. 22/23, same order. Then 26 also,
24 also.
3172.
100% reservation, 26/26.
This year, written purpose.
Acha.
27.
Acha, 20, yes, Mr. Rao. 27.
I'm sorry, my lord. In this matter, my lord, 27, my lord, GO, my lord, 72 question. That this honorable court pleased to granted the order. My lord, last portion, you have the foresaid submission with view to maintain the party and for the reason that the same facility given the my lord, GO also. My lord, only, my lord, kindly see, my lord,
This is the interim order. These petitions, everything is coming up on 7th September, if you have seen this order.
my lord.
So it will, this is the interim order and it will come up on 7th. In the meanwhile, he will file counter and we will intend to hear.
Please.
7th, Madam, 27 also same order, Mr. Rao. And then 28 also.
28 not.
28 is not.
28 is there.
28.
28 is there already. Give madam 28.
Uploading.
30, 31, 29.
1 minute. 28 is similar, Mr. Rao.
28 million, this
Different.
registration.
Registering.
Registration.
Different, right?
Separate.
Separate. 29, then which other?
29 same. 29 same.
29, 30, 31, same order, madam.
34 large.
And 34,
34.
same order. Huh? So like it's all same order. What are the numbers, madam? 20. In which case 22, 23. 30. Yes, all same orders. 7th September. Now yes.
All the cases will have posted on 6/9 minutes.
7th September. 7th.
Obliged.
7th September. You will file counter.
Obliged.
24.
6th malad. It's posted on 6th.
24.
Batch matter is posted on 6th malad. 6/9.
6/9, whatever. 6/9. Whatever is the date it comes.
Yes,
up,
ma'am.
that day. Yes.
Direction will have
1 minute. This let 24 be called. We will come. We have passed orders in 24, 27, 29, 30, 31 and 34. Same order coming up on 6 September. Further date of.
my band is 28.
We have not yet called, we are at 24 now.
Yes, please. Lordship, one humble request is,
Ah.
order copy may be, interim order copy may be made available by tomorrow. Obliged, deeply obliged. Correct.
Item number 24, Malad. Malad, the petitions complaint before your lordship.
PCB is not taking any action,
Yes, sir.
and we are imposing.
Malad,
Now we are
it was
imposing.
plundering the nature.
One
Malad,
minute.
yeah. I leave it.
You are not taking any action. People are flocking to this court, right? And you are apart from you are competing with the state government in generating litigation, right, Mr. Your officers all the time keep on sleeping, and when they only wake up to engage you.
With your
No,
lordship.
no, it's a serious thing, Mr. All this thing petitions like why he is coming here. That I made a complaint. That complaint may be correct, may not be correct. God knows. Your officers will know. And this thing. But you don't respond. Why should you not respond? Tell us.
With your lordship's permission, my lord, in this matter, what had happened is multiple representations have been given over a period of time. Action has been taken. Some of
Where
the
is
reports
this?
are, some of the reports are also
All right. Learn it. Yes, in this 1 minute. We let him file a report. In this.
The cabinet secretary making a party, with references. Not even a single reference to the central government.
Yes, Mr.
Malad,
And the file conference will have
like to make two submissions. I'd like to make two submissions. But it's a fact that we have been presenting representations. The board is doing an IWAS job. But they consider, they pass an order. Again, they allow the very errant company to go ahead with the pollution. That is the problem.
No.
At page
Sir,
75.
1 minute. First submission is, their submission is that why have you Union of India through Cabinet Secretary?
Malad,
What is this sort of impleading? So you will have to correct the cost title, right? You will have
I do
to
it.
learn
I do
it
it.
counsel for the
I could have avoided it.
under to do it today just now before leaving the court hall.
Yes.
Just now. Learned counsel for the petitioner undertakes.
With your lordship's permission, my lord. In fact, the company against which these allegations are being made, the matter is currently pending before the Honorable NGT, my lord. Subject to your lordship's decision, my lord, OA 97, my lord. In fact, some of the orders are also filed in this. The very same company, the matter is being adjudicated. We leave it to your lordship, my lord.
Malad, this is one.
No, all oral submissions we should like. Will you not mention it so that he knows? He is resisting every attempt to go to Chennai. He wants to go to Delhi. You are sending him to Chennai. It's like this.
No, my lord. I would make one small submission. my lord.
No submission. He will file a status report with regard to action taken on your representations. Correct?
If I
This is
can
only entertained. Ideally speaking, you should go to NGT.
my lord, an humble appeal.
If he says so that this action against the company you are seeking is before NGT, we will have to relegate you to NGT. But
Well,
we want a statement on affidavit.
I want to make one small submission and I leave it to your lordship. My lord, yeah, for your lordship's discussion. My humble submission before this honorable court is this. This is the game played by the ninth respondent.
No. So they should be hanged right away.
No, I am not asking. I am not asking.
11:35.
No.
Game.
My appeal to your-
Mister, please understand.
Let there be
Please understand. We are asking them to file a status report.
pleasure. I thought I could make one small request.
You thought that the petition is being dismissed, right?
No.
That you should tell us alternative remedy of approaching NGT. Why are you coming to this court?
No,
That you should tell us.
well, that's
NGT has jurisdiction. You answer with reference to case laws. How can you land straightway High Court and then why not under Article 32 before Supreme Court?
like that.
Right to environment is a healthy environment is a fundamental right.
Article 21 and
21.
Therefore, the sentinel quiver.
No.
Your lordships have got a greater responsibility.
1 minute. Don't tell us about our responsibility.
Yeah.
What we are telling you, we are conscious about our
No,
responsibilities.
that's what
We
you are-
don't need.
Your lordships have said
No,
so.
we don't need Mr. Reddy to tell us that, and Mr. Gummi Damodar Reddy and Gummi Narendra Reddy to tell us.
They will never
what are our responsibilities.
They will never venture. Never venture.
Then don't tell us. We are trying to tell you, we are asking you a legal question that why you should not go to NGT, answer that. Because you have not brought anything, case law, nothing. Why you
Coming up only for admission, my lord.
Therefore, we are asking them to file a status report. Next day,
I leave it there.
next day, you tell us, we are putting a query to you, sufficient notice to you, study
Yes.
why you should not go to NGT.
Yes.
That doesn't, so you have said that right to healthy environment is fundamental right, then we can tell that for violation of fundamental right, further remedy directly under 32 also lies. We can also say that this court read 226 lies for violation of fundamental right and statutory right also. The jurisdiction is wider.
Right.
32 is also lies. Go to Delhi. Straightway.
Well, I don't,
no.
I don't add a word. I rest there, but I have seen.
Third, in this writ petition format, the petitioner seeks a direction to respondent number 5 to take an action against respondent number 9 industry for causing causing pollution by releasing poisonous effluents in the lands belonging to the petitioner and belonging to the petitioner. Full stop. The petitioner inter alia seeks a direction to the respondent number 5 to also seeks, not inter alia, also seeks a direction to respondent number 5 to close the industry paragraph. When a query was put to learned counsel for the petitioner about availability of alternative remedies to him, learned counsel for the petitioner prays for adjournment in order to enable him to prepare the case on the aforesaid aspect and to address this court on the next date of hearing. Mr. Under Air Act, Water Act, the Pollution Control Board has power to close the industry. Right? Have you this thing, Mr. Pollution Control Board? We will, Mr. All you of your officers, right? Put them on warning. And you should come up in some case in today itself with the timeline. That action on the complaint will be taken within 30 days, whatever days, and produce it. Otherwise, he will land in trouble, Mr. Your chairman, member, secretary, or whosoever whom you think is your boss. We will not tolerate this. Every case, everybody is approaching this court, and you are competing with the state government to become the one of the biggest litigants in Telangana High Court, right? How many cases you appear every day? We see every day. And why? Why you are required to appear? Because you don't take action. They are helping you in generating litigation. They're public body, right?
Yes.
Meant for public or anti-public. You are in existence to harass people or to work for them. Huh?
For the people, madam.
Then is it working?
We'll take instructions.
No, you come. Should tomorrow itself you should come out that this is the timeline we have fixed for taking action.
Yes.
Learned, however, Learned Council for Telangana State Pollution Control Board submits that the action on the representation submitted by the petitioners from time to time has been taken. He, however, prays for and is granted 2 weeks time to enable him to file his status report. Each status report list after 2 weeks. Right. Lordship, the writ petition, somebody is appearing, right? Through video conferencing. Huh? That's why you're looking there. Who is appearing? Lordship, the writ petition. Nobody is there. No, there's somebody. You are arguing. Yes. Then why are you look? We thought that somebody is looking through video conferencing. So we were looking at the screen, but there's nobody to help you there. I beg your pardon, Lordship. I didn't. What's the problem with this? Lordship, the writ petition has been filed against a warrant of position for the immovable property. My Lordship. Lordship. Order passed by DRT under which provision of law? Lordship, the warrant has been passed. No. Which provision of law? Surface Act. Not surface. RDDR. What is the remedy? It's we find a third party claim petition, my Lordship, before the recovery officer. So this thing, pull the mic towards your mouth. Yeah. We find the third party claim petition, my Lordship, before recovery officer, my Lordship. Third party can file an appeal also under this thing, Act 93 Act. Yes, my Lord. You file alternative remedy. Lordship, our right of the position notice has been issued. Mister, we ask you under which provision Debt Recovery Tribunal has passed an order? It's RRD Act. RRD Act. Against order passed by Debt Recovery Tribunal, appeal lies under section 19, 20. Yes, 20. File an appeal. Our fundamental Satyavati Tandon. Yes. It's 300 A is violated, my Lordship. That appeal, that right can be taken note of in appeal also. Yes, my Lordship. Yes, my Lordship. Lordship, file an appeal. In Calcutta, my Lordship. Also there, people go to Delhi also to file writ petition. They don't also SLP. They don't say. My Lordship, Mr. Rao will not say that I have to go to Delhi. Therefore, you entertain petition here only against your order and grant me stay. He won't say that. My Lordship, he will go to Delhi till 2 weeks to file a bill in this writ petition. That Satyavati Tandon, another thing you have in this writ.
Obliged. May I please? Petitioners are working as postgraduate teachers in the second respondent society, not the
Validity of. Heard on the question of admission, petition is admitted for hearing. Notice.
interim orders have been passed below at page number 92. Similar orders have been passed by the division bench below at page number 84 and 92 below.
84.
84 to 90
Operative
and
86.
96. Batch of revisions are pending below.
What status quo?
Status quo that has
Say
been
what is status quo?
It's not the-
Status quo is as vague as it can be.
It
What
is-
is status quo?
in
You
fact,
have challenged the validity of.
yes, but in other case,
Validity of a statutory order.
page 94 interim
No,
suspension.
no. Status quo means what?
They are allowed to continue same place, madam. In fact, as of the day, they are continuing
No,
here.
no, we will not.
And page 94 is below stayed below. Interim stay has been granted. In another,
Memo, this thing.
What is types of rules? No. But it would be in one seven, they issued a memo saying that not putting this people.
We pass in. Heard on the question of admission, petition is admitted for hearing. Learned counsel for the petitioner submits that the writ petition involving similar issue has been entertained and an interim order has been granted in support of aforesaid submission. And there shall be stay of order of allotment dated 26/9/2022, comma, if the same has not been given effect to
very well,
till today.
very well.
List along with WP number so and so for analogous hearing.
Obliged.
Student takes.
But see, see the obligation.
Yes, you will consider
Yes, but 22, page 22 below, order, same order.
page 22. All right. Heard on the question, petition is admitted for hearing with consent of parties, same is disposed of. Page 24 and 25. Accordingly, petition is disposed of. Yes. This was item 28.
CC today we will.
CC today. Oh, his word is more effective than us. He's so liberal for management and NRI quota. Very magnanimous attitude of university and Mr. Rao.
My friend has not made an application.
Management quota.
He has to file a representation.
Arey, which case?
Yes,
You have not filed a representation.
no minute.
You have to file it.
Give that file.
After 28.
28. Same in case petitioner submit a represent, same order here also.
Yes.
Correct. Same order. 32. Yes, management quota.
It's also same, Lord, yes. He has already submitted representation.
Page
Page 22 below. Page
24.
21.
Madam, with consent of the parties heard finally, and page 24 is the order. Right? Disposed of.
May it please. So the petitioner is entitled for economically weaker section category. She was denied the same lordship. The certificates, lordship, which establish a genuineness after
So,
pages.
yes, Mr.
Bloody submitted a representation, Lordships.
So shall we ask them to consider?
Well,
Page-
consider.
Page 19.
Page 19 is the representation.
Pending rate petition, you decide. Otherwise, he will again.
Yes, sir.
Sorry, Mr. Why should you stand?
Yes, Lordships. Lordships, Lord, I am told, Lord, that the petitioner has to enclose Lord certificates in online application. He put yes, Lord, in the EWS. But I am told his relevant certificates are not enclosed.
Yes, lordship.
Now they are filed here.
In fact, the certificate was enclosed, your lordship, but it appears, your lordship, page 15 certificate. There's some minor deficiency again.
The
He obtained
petitioner
a fresh certificate and again submitted it.
will dispose of, Mr.
Yes, lordship.
Yes, the mark the presence with consent of the parties matters heard finally in this writ petition, the petitioner inter alia is agreed by the action of the university in not providing admission to the petitioner under economically weaker section category in NEET for admission to MBBS MBBS course for academic session 2023-24. Paragraph, learned counsel for university submits that the in case petitioner submits a fresh representation, submits a fresh application, fresh application.
Already applied. He has to enclose Lord fresh Lord the income.
Learned counsel for the university submits that the petitioner has already submitted an application for consideration of his case for admission under EWS quota. EWS quota. However, the requisite documents were not annexed with the application. In case now the petitioner has furnished, now it is also submitted that now the petitioner has furnished the requisite documents in support of his claim for admission to EWS category for MBBS to MBBS course for academic session 23-24, and university shall consider the same. Paragraph, in view of aforesaid submission, learned counsel for the petitioner submits that the writ petition be disposed of with the direction to the university to consider the application submitted by the petitioner for admission to MBBS course 23, right? Everything, man. Paragraph. In view of aforesaid submissions and in the facts of the case, petition is disposed of with the direction to the university to consider the application of the petitioner for admission to MBBS course 23-24 under EWS quota within
1 week, Lord.
Within 1 week from today. Accordingly,
The petitioner already got admission in government medical college, but if he considers in EWS, he may get better college.
better within 1 week. Accordingly, petition is disposed of.
Obliged.
It's right, madam. Made clear that we have not expressed any opinion on merits of the matter. Merits of the claim of the petitioner.
Obliged.
Encroachment of public property. There is already an order.
It is pertaining to the Sardar Vallabhbhai Patel, sir.
You know what counter you? Nobody wants to fight counter. They don't want, so be happy, Mr.
R3 was like by the status report.
My lords, I appear for respond number 3, my lord. But my instruction that the eighth respondent was granted construction permission.
What action have you taken in pursuance of represent?
My lords,
Mr. We have to hear you, pass an order. Then next date we tell you what order we passed on the last date. Huh?
My last kindly consider the allegations in the representation is that, my lord, to protect the land from the hands of eighth respondent, my lord, the
Mr. Rajendra Reddy, we had directed you to file a status report
yes,
in this matter. Whether the construction has been carried on with by obtaining a permission.
yes,
Where is that permission placed before us?
my lord, may grant 1 week time, my lord, I'll file a detailed
That's
count.
what you are supposed to do.
Yes.
And they had given a representation on 6/3/2023.
Yes,
If permission was granted and construction is progressing in terms of the permission that was granted, why did you not respond to them?
yes,
So everybody gives a representation has to approach this court, saying I have given a permission, I have not got any response, so please inquire into it and see that we get some
No,
response.
we will direct the state government to supersede you. Because it's failure to perform statutory duties. This municipality should be superseded. Administrator, you appoint an administrator, administrator will engage another council, replacing him. This is what you want. Why don't you take action, mister? You are unable to tell them
my lord,
that
sir.
for your inaction, everybody approaches this court like pollution control board.
No, my
You
lord.
are also like local bodies, everybody like equal partner in the this thing for enhancing the arrears and of cases. You take pride in that. That at my instance, one petition is added to the vote.
My lords, my instructions are that, my lord, the subject land is, my lord, exempted from the provisions of Endowment Act.
We will direct his personal appearance.
Page number 75.
One minute.
Much.
We are dealing with. So who is commissioner will appear in person, right?
Yes.
When will he appear? Should we issue bailable warrant or he will appear?
He will appear.
Huh?
He will appear. And also I'll file detailed counter.
That is, we are directing personal appearance on account of your inability to give effective instructions to your client and
My lord, my
saying that instructions are like this.
my lords, may kindly
No,
consider.
no, we cannot make a pickle out of your instructions, right? That's why we are directing. This is an order passed by you, by us on 24/8.
Yes.
In your presence, you don't know. And you are saying my instructions are as if you have gone to moon and come back. You are telling us what did I see in moon? Commissioner municipality went to moon along with Chandrayaan and he saw, and my instructions are that he's noticed lot of water there.
I'm sorry, my lord. My instructions are that the representation hasn't been acted upon since there is a construction permission, my lord, granted in favor of the eighth respondent.
Mr. Counter affidavit, you are not filing. None of them is saying that Mr. GP. Again, back to old tricks, right? Just standing up, looking at the court. This is an order asking you to file a counter affidavit.
Yes.
This lawyer is standing, not saying anything. You are standing, not saying anything. The presumption is you don't want to file a counter.
No, Lord. The last occasion, Lord, R3 was directed to file status report, Lord.
Mr. This is pity.
Counter if any, Lord.
No, have some compassion for us.
Yes.
That we pass an order, then next date we tell you what is the order. It is open for respondents to file respective counter affidavit. You say I don't want to file. The presumption is we will draw is that you are standing, you people, you don't want to file counter, we will deal
Next
with
time,
it.
Lord. Next time, Lord, we'll file counter.
This is not a wedding happening here that whosoever is invited will come. Otherwise, I will not. So Commissioner Municipality is invited. So we will, GP Revenue has nothing to do. I am not invited. How can I go to marriage, attend marriage? Not happening.
Lord,
We will direct Commissioner also to appear this thing.
my apologies.
Principal Secretary Municipal Administration, whom you represent, he will also appear.
That's my apologies, my lord.
So the legal constraint.
Again, back to old tactics, Mr. So we did not install, Mr. Praveen Kumar only will be exempted from that live shock system. And it will cover all of you. So we will, because see, I am straining my vocal cord by saying all this which is unproductive.
My
So
apologies.
instead we will
My apologies.
press this. So you will just jump up like this thing. Shock. Unacceptable conduct, Mr. Please cooperate. Now I have spent 5 weeks. By that time, if you have not known the judge, we can't help it, right?
It's the week's fine, maybe granted, my lord. Conditional appearance, my lord, account is not filed.
Learned counsel for respondents pray for and are granted 4 weeks further time to enable them to file counter. It is made clear in case counter is not filed on the next date of hearing, appropriate order shall be passed.
Deep judge.
I'm sorry, ma'am.
Much of. Maybe, sir.
What is this admission? We will admit it.
My lord, it can be disposed of.
Dispose of. Then at the, if you want, this is 23 appeal, Mr. We can't, we can't decide the cases like this. See in the final hearing, 2005 appeals are pending. The appeal is admitted for hearing. Please move an application for urgent hearing. We will consider, right? Appeal is admitted for hearing. Interim order granted on earlier occasion shall continue. Yes, next.
There is no interim order.
No interim order. Then fine, appeal is admitted for hearing.
May it please, my lord. My lord, this relates to a student's date of birth. It came up earlier before my lords. I've prepared a small list of dates, my lord.
No, it's for admission.
Yes.
Please argue. This is after 5 years,
Yes, my lord.
Waking up like joining service 30 years ago. Then, and when the retirement approaches, then seeking that I was born this day, all this.
My lord, he's not seeking public employment. And my lord, the earlier round of litigation was there. Where, my lord, this court directed. My lord, this.
All right, we'll admit it. Heard on the
69.5.
The issue involved in this intra-court appeal pertains to interpretation of
Bylaw number 69.5.
bylaw number 69.5 of the bylaws. The appeal raises an arguable arguable point, hence admitted for hearing. Yes.
Would your lordship be kind enough to grant some date, my lord?
Please file an application.
Very well.
That we have been telling everyone. Please.
Very well.
See, you will realize that initially under our enthusiasm of deciding, we have fixed the date. You are correct. But see, every case now we have realized can't be decided at motion hearing stage. And 2000, we don't see absolutely no justification why 2005 litigant should wait.
Very well.
But still we'll try to find out time and hear your case if it's possible. Yes.
I've prepared a short synopsis below. Process below.
Hey, what is it? Alternative remedy of appeal. You don't want to go. Everything here, and maybe you should take a longer route of 32 also. Supreme Court directly. All litigants land here saying everything. Encroachment, encroachment, pollution, what not, everything under Article 226. And bank, this thing, borrowers, everybody don't want to file DRT, DRAT, pollution, nobody wants to go to NGT. We should have probably 500 more judges and abolish civil courts and convert everything into declaration of title, this thing and everything here. FEMA also we should hear. Yes.
My lord would appreciate
Pay to pay, that's all. But what separate people, then all these cases, they say alternative remedy. This thing.
I've sent a short synopsis below. May I pass on with the Lord's kind permission? One Supreme Court judgment.
1 minute, give us 5 minutes, please. We will hear you, of course.
I'm obliged.
Nobody is appearing to oppose you, Mr. Advance copy you must have served, no?
Yes, yes, I have given.
Uh-huh. You are here. Please sit down. Yes, please.
I have given the extract from this decision.
Which decision?
The 257 ITR 338. Here it is a direct application. It covers. Here also, section 276 DD was omitted without any saving clause for the pending proceedings, where the omission is omission simpliciter. Even the pending proceedings get abated is my first proposition below.
Which paragraph? This 257 ITR, which para?
338, this paragraph is
No para.
actually I was,
No para.
yes, at page, here, my lord,
Which para you are relying?
we find the submit. In the last page, my lord,
We find.
third unnumbered paragraph, we find the submissions of learned counsel. Now, in the case of fiber boards, which I have already,
You are required to deposit some amount if you file an appeal.
yes, my lord, 50%. 50% that,
That's why
that is
you.
about it. Not only that,
No, we are just asking that
Yeah.
this doesn't depend on interpretation.
Section 19, of course, there is discretion in the hands of the appellate tribunal to waive or reduce and all that. But my submission to Milord is, it is without jurisdiction
And
and
therefore,
it is neither efficacious nor adequate. I mean, all those, that is why the alternate remedy is no bar for invoking the jurisdiction under 226. Here, two grounds below.
so which, please read, though we find submission.
We will not start.
Please read what you relied on this, though we find submission, right? Which para? So read, please read the para so that.
I'm sorry, I'm a little out of.
Page 5. Last but one paragraph. Page 5 of.
You just referred to it, right? Please read it.
Yes. Though we find the submissions of learned counsel to be forceful, we are constrained to follow the decisions of the constitution benches of the court in Royal Corporation and Kolhapur Sugar Works. This view has held the field for over 3 decades and reiterated even as late as 2 years ago. Non-compliance with sections 269 SS of the Act attracted prosecution as well as penalty. Omission of the provision regarding prosecution will not affect the levy of penalty. The advantage arising out of application of the ratio of the two decisions resulting in prosecution in cases of non-compliance with section 269 SS of the Act is only transitional in a few cases arising prior to April 1, 1989. Such cases may be few and far between. Since we find this is not an appropriate case for reference to the larger bench, the result of this discussion is that the view taken by the High Court is not consistent with what has been stated by this court in the two decisions aforesaid, and the principle underlying section 6 of the General Process Act, saving the right to initiate proceedings for liabilities incurred during the currency of the Act, will not apply to omission of a provision of an Act, but only to repeal. Omission being different from repeal, as held in the aforesaid decisions, in the Income Tax Act 276 BD stood omitted from the Act, but not repealed, and hence the prosecution could not have been launched or continued by invoke. Nor can it be continued if it were already pending. In my case, it is squarely covering with.
Raila Corporation, where is the judgment and where it has been subsequently considered, Mr. If you can tell us.
In fiber boards, no, that is Royal Corporation has been considered in Kolhapur also.
So, fiber board, what is, you first read Raila Corporation and then fiber board.
Of case laws, Royal Corporation and fiber boards are in that.
Arey, Mr. You are ready, no?
Yes. The first case law there is Royal Corporation. The running page 11, paragraph 14 at the bottom. There remains for consideration the question whether proceedings could be validly continued with the complaint in respect of the charge and the rule so and so of the DAR, Defense of India rules, against the two accused. The two relevant clauses may not be relevant for our purposes. Then Milord may come to running page 12, the middle paragraph, beginning with the argument of Mr. Sen was that even if there was a contravention of Rule 132 capital A by the accused, when that rule was enforced, the act of contravention cannot be held to be a thing done or omitted to be done under that rule.
All right, we are admitting, we'll decide this.
For the petition to overchips. And for the petitioner.
Nobody is appearing for human rights, right?
Yes, yes, your lordships.
Nobody is appearing.
Yes.
Nobody is appearing for human rights.
Somebody appeared directed them
to make a statement. We asked you only. You are appearing for petitioner.
Yeah. Last citation, your lordship has given our instructions for the
make a
compensation.
Willing to help nephew. He is an order. Except you, who is nobody in the. He has nobody in the world, right?
Yeah. Present.
Then what can you do for him?
Presently, that boy is studying in the Karimnagar Social Welfare Hostel, and his boy is taking care of this petitioner and as
Trial
well
court
as
is taking care.
grandmother also.
Trial court.
Yes, no, Karimnagar Social Welfare Hostel. Boy is studying in the 6th standard, Your Lordships. Last occasion, Your Lordship has given me oral direction saying that regarding the.
No oral direction. This is what happens when we say something in good faith. This is how we are quoted. Oral direction and all. Don't do it, mister. Otherwise, we will stop saying anything on the dais. This is not fair. There is no oral direction. There is all in writing. Because he is not our nephew, right? He is your nephew. So, if my nephew would have been there, he would not have been required to come to the court for seeking maintenance, right?
Yes.
And I am sure about your nephew also. If you had a nephew, he will not come to the court seeking that maintain.
Absolutely right.
So that's why we have, it's not oral direction. This is a written direction, nothing illegal about this. This is an order in writing. Learned counsel shall seek instructions and make a statement about the help.
Yes, Your Lordship, I obliged.
No, we are not sitting here to read it out to you. Go through it if you don't know the order.
We are
This
ready
is not the job of the judge that you won't know an order pass in your presence. You will say anything.
So we are ready to take care of the. Just we are.
Show it to him.
One humble submission, Your Lordships. As per my instructions, he is ready to pay the 2,000 rupees per month, and he is taken care of by his uncle. That's what I got the information.
That's what you should say. That I have counseled my client and he is ready to. What is he doing?
Per month, 2,000 rupees and other welfare of the.
Street vendor, right?
Yes.
Then say so. You are not saying basically we thought that he is a industrialist, exporting industry.
Running the Mirchi Bandi business, Your Lordship, he has the 4 children. That's what just he is.
Learned counsel for the petitioner submits. What is it, mister? Now your turn. Your government leader, right? Now we should pass on the order to you also. Otherwise, you will say that Article 14 is violated. It is shown only to the petitioner.
Lordship, my instruction.
What did we tell you last date of hearing? The child is entitled to protection of fundamental right under 21A up to the age of 14 years. And what have you done?
Lordship, my concerned officer inquired. He has been pursuing a 7th class under at Karimnagar, some trust, Lordship. So therefore, he has to be continued.
What?
Trust or your social welfare school?
Bala Gokulam Venkata.
He says he is in social welfare school. You say he is in the trust. Which trust?
Bala Gokulam Venkata Foundation.
But what we said, please file a status report. Nothing is
Learned comment either praise warrant is granted 2 weeks time to enable him to file an affidavit about the pleading particular disclosing the details of the school in which Master Jaswant Kumar is studying. The statement made by learned counsel for the petitioner fairly submits that the petitioner is willing to extend the financial help, shall extend, not willing, shall extend from, you start doing it from August itself, shall extend the financial help of rupees 2,000 per month to his nephew, namely Master Jaswant Kumar, who is the son of his deceased brother, with effect from August 23. We place on record the aforesaid submission made by learned counsel for the petitioner. We also appreciate the effort made by learned counsel for the petitioner in persuading the petitioner to extend the financial help.
Lordship, with last permission, the response number 1 is not, the
You
petitioner did
file,
not.
file an affidavit, or we will ask him to remain present in case you are unable to do so.
The petitioner did not make a proper party, Lordship. It's it indicates.
So we have said,
Department.
delete, petitioner is directed to implement
Women and child welfare.
Secretary, Women and Child Welfare Department as a respondent in this petition. Let necessary amendment in the cost that will be made during the course of the day. Then notice on behalf of respondent is accepted by government pleader. First thing is not proper party. Important thing is not affidavit, but important thing is description of property. Here, a future of a child less than 14 years is at stake. You should appreciate that, but technicality.
In the absence of the proper party, therefore, I Lordship consent to.
Now there is a proper party. That proper party will appear now in person in case you don't file an affidavit.
Affidavit consent
Then
department.
that let affidavit be filed within so and so. 2 weeks, failing which appropriate order shall be passed.
Deeply obliged.
You are unable to say, Mr. You are saying that he is saying in an educational institution owned by you. You are saying trust. That's why affidavit.
Therefore,
Therefore SLP against this order. File, go to Supreme Court. Yes.
the affidavit to the extent of the competent body.
This matter, that is the number 1, the central government, the Ministry of Health.
Yes. You last time also.
Yeah, first counter today.
Today.
Yes.
Would you like to go through it?
We have gone through, my lords. Nothing is there.
Nothing. So what is this, Mr.?
Only thing, my lordships.
Tell us briefly what is this for admission. What is the issue involved?
Yes, this is with regard to my lord, withdrawal of the permission by MARC, the autonomous body of NMC, stating that the college facilities are not good. We have prepared an appeal, second appeal. And second appeal is under challenge before this honorable court. Plus, my college is recognized for next academic year and thereafter also.
Oh, yes.
For 3 months, 4 months.
This needs to be heard then. Yes. Please prepare a synopsis.
It's a transfer, my lords.
Please prepare a synopsis. Show these are the deficiency. Last date also.
It is
deficiency pointed out. This is the compliance. We will hear you.
May I submit, my lord?
Update beyond 30th of August. Importance of 30th August, you know.
Yes, my lord. May I submit, my lord, one submission, my lord? In this case, my lord, permission was already granted to the medical college. We admitted the students. After admission.
No, you realize, Mr. For what purpose it is listed today?
Yes, lordship.
What is the best order you can get?
Yes, lordship.
We are granting it.
Yes, lordship. Only
what the endeavor is to, under the heading admission, you want to argue it finally right away and get. That's the problem. He has understood. That's
yes, sir.
Best order you can get is an order of admission. We are granting. Petition is.
But the definition,
if you
file an application, we will consider that an early. Everybody we are telling senior counsel. Everybody we are telling that if the petition is admitted, all petitions cannot be heard at motion hearing stage, right? So please file an application for urgent hearing, fixing a date for hearing. We will fix it.
May I suggest one, my lords? Because since it is being last 1 year, my lords, we have been arguing this matter. Almost it is heard. Because one of the colleges is concerned.
Not arguing. 1 year I have not been here. This is my 6th week.
My lord.
We don't know. And I cannot take responsibility for what happened 6 weeks ago.
Lordship may fix a date, my lords, otherwise.
That's what we are saying. Admitted for hearing, not fix a date. You file an application, we'll fix a date.
Yes. May I make one submission with your lordship's kind permission, my lord? One submission.
Which case you are appealing?
Item 41, my lord.
All are connected.
Item 41.
He is making a separate submission. We will
only
pass a different order in his case. 42, 41, except 41, everything else is admitted.
If
Learned senior counsel is granted the liberty to file an application fixing a date for hearing, right? Or fixing a date of hearing. Please fix a date. We will fix a date, please. File an application. What about 41?
Your Lordship, on 16/9/2022, Your Lordship disposed of my writ petition, directing the central government to consider the case on
41.
41, my Lord. Your Lordship has disposed of my writ petition, earlier writ petition.
So it has wrongly listed.
No, Your Lordship, it has this. I filed a fresh writ petition. I filed a fresh writ petition.
It is pending. He said that it has been disposed of, wrongly listed.
No, he's referring to earlier round of litigation. Earlier round of.
It is for admission, so it was disposed of, correct? Then what happened?
I will file the application, my Lordship.
Students are double.
Yeah, that's the best part of the day, that we are able to smile, right? That's the best part.
Peace, not Mellows, peace.
41 is also admitted for hearing.
With liberty to.
Not attending classes are not getting medical education. They are all getting. It is the colleges which are proxy litigation.
Yes.
Yes, madam. That you should have said. How you are saying yes?
The academic year has completed. Students have been shifted, my lord. At this stage.
We will, yes, let them file an application. We will consider. Yes.
But one
Yes.
set of students are there, but still who want to pursue with this college because they have joined without.
We have admitted it. Please file an application for urgent hearing. We will fix a date. Yes. Yes.
Finally taken up 2 weeks time, my lord, the filing counter.
Petition is admitted for hearing. 4 weeks time is filed. Wanted to file counter.
48 and 49.
NG order.
That's appearing to the respondent.
You have understood, right? What is the need to make this thing?
Yes,
So
sir.
see,
Instruction
the
already.
members of the bar had a grievance that certified copies are not being delivered on time. What we have done is, we have come out with a chart. Have you seen that?
Yes, my lord.
Ask Mr. Praveen Kumar, my lord.
Yes, my lord.
This is what you are required to do.
Yes.
Just few days, just few cases ago, we were telling you to come out.
Yes.
Please come out with this. Complaint file, action will be taken, whatever its time limit. And whosoever does not adhere to the timeline shall be deemed to have been suspended. You write like this.
Yes.
Deemed to have relinquished his office from the expiry of timeline.
We'll prepare this thing, my lord. As per your lordship's directions, we'll prepare it and come back.
He will not be entitled to salary for the period beyond this thing. Is deemed to have relinquished instead of relinquishing. Shall not be entitled to salary till the application is decided or action is taken.
Yes, we'll do that.
They all have on the wall.
So brother is saying that is called citizen charter.
You have it on the wall, only for the sake of being hanged on the wall. No action is taken. You have a list saying representation 3 days. That citizen charter is only put on the wall, not implemented.
Yes.
So it's 48 and 49 is seeking an adjournment, my lord. We'll get back with some instructions, my lord.
I appeal for the petitioner in 48.
No problem, right? If stay is granted, no problem. They should seek 1 year's time.
Lordship may accommodate us once, my lord. We'll come.
You want to fight counter?
This 48 and 49 are connected, my lord. In fact, both the petitioner in 48.
Why do you want adjournment, Mr.? We are only asking that. We are not asking that they are not connected.
We'll file a short report in 48, my lord. We'll file a short report.
Report what? Report about?
My lord, basically the matter here is about the challenge to an NGT order.
No. Despite that, you are seeking an adjournment. You will tell us what is it. Do you think that we have not read it?
No.
Listen, order.
No, madam.
We know everything.
Yes, ma'am.
We are asking about report about what?
The status report, madam, in general status report, so that the pleadings
One
are complete.
sentence, Mr. Counsel. One sentence.
My apologies.
Still, you have not told time. We will say tomorrow before 11:45 p.m. Because you have not told when you file a status report.
2 weeks time may be granted, my lord, your lordship may have it.
All this is required when
My
you
apologies.
want, right, like that I should give sufficient exercise to my vocal cords, then only you will ask for an unproductive thing as you are saying. Council for Pollution Control Board place warrant is granted 4 weeks time to enable him to file a status report. Right. This one. This one.
And for the petitioner, my lord.
Right, madam.
I beg to represent Mr.
You are
Dominic.
counter.
Yes,
How much time?
2 weeks, my lord.
4 weeks time is granted to
Your lordship, the
I
interim.
counter interim order shall continue.
Obliged.
Yes. What is this say? Requires this is completely admitted to learn.
1 second.
What?
This is challenge to provisions of the section 17,
Yes.
5 of the GST Act, ready the circular flyer that was issued.
Yes, my lord. That's right.
Admitted for hearing, madam. Yes.
Lordship,
Regarding
the
box
interim
farm.
order be extended me.
We have already,
Obliged.
without hearing that you are leaving the court hall, madam.
Right. Look, I was here only, my lord. I have not
No,
said.
no. So did you not hear telling
I
this court
that-
that it has, then why are you saying that it should be order is not being altered. It's only being admitted.
Deeply obliged.
I request for some time, your lordship. The matter is now placed before the rule committee. Your lordship.
Before the rule committee with regard to knowledge. How much time
Lordship,
to file counter?
lordship may consider granting 4 weeks time. It's now placed before the rules committee.
So and so 4 weeks time is granted to enable him to file counter.
Obliged.
I am appearing for R3 in this matter. Yes, I'm appearing for response 1 and 2, my lord.
Minus. Admitted for hearing. Counter if any on behalf of respondents be filed within 4 weeks.
Yes. May I please? Yeah, this is with regard to your lordship, this is a medical local photo ballots. This is absolutely covered by your lordship judgment in item 1 to 15. Whereas
10 to 13. In this petition is admitted for hearing with consent of parties, same is heard finally in this petition. Where is that judgment, madam?
it is your lordship dictated.
From 1 to 13.
1 to 13 judgment.
Morning, 1 to 13. Judge.
This he has taken away.
Taken it for
In this petition, the petitioner has impugned the validity of rule 3, number 3, within bracket Roman capital 3, within bracket capital B of Telangana.
medical and one.
Yes.
Petitioner did not challenge any rule. But the petitioner did not challenge any rule.
They filed an IA. That IA.
Amendment.
Amendment is filed.
So then before
IA
that, madam, heard on IA number so and so.
And amendment copy is also filed.
1 minute. Heard on IA number 3 of 2023, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amendment
That is why
the neat copy has already been this court white a common order passed in WP number 21268 bar 2023. Madam, you can't have a spare copy of the judgment. You can't have. Madam, today judgment is delivered. Today judgment is delivered. The copy is, you cannot take a printout of operative portion. Then where is it? No. Then make a photocopy if not available, or ask him to give a printout additional copy. I will henceforth ask him to prepare in 2 copies. This court
May I
might-
take one or may I read?
Of course, I mean, we don't know why it has been taken inside, Mr. Rao. It's very strange here. I'm sorry. This judgment is ready and it is signed, pronounced, and they have taken it inside. Why, madam? Who has taken? No, but that's correct. But they should see, right?
Allowed to
Then
system, you should have the permission of the court to peruse the judgment. We would have given it. Normally, once it is signed for being initialed on other pages, it is kept on my lord's table. That can't be a complaint.
May take the copy home. That's
We'll try to upload it today itself. If you want to peruse, normal system is they will have the permission of the court.
Yes.
We may be permitted to peruse it. You know what happened in ITC judgment before the Honorable Supreme Court? Without my lord's Justice Rumapal's permission, the order was taken out and taken to Xerox Center.
One minute, Mr. Rao. I will sign it just now so that there is no problem. No, but I thought that it's available and you must have seen it. See, with great difficulty, we found out where it is kept ourselves. The author also has no access to the judgment. It will be given to me. Now, people not in the city. But this, we want a copy. No, I will already just send the instructions. It will be uploaded in July. So, people have to implement this. Yes, one more thing is one of it is not replicated in that. It will be done. Now it will be done. I've seen soft copy they will not PLM ki చెప్పండి soft copy dump చేసేయండి dump చేసేసి so that let them start putting it in the website that this Tell whatever, whosoever. You will be here till 1:30, then who will do it there? Tell.
We found already for that some facility. Okay.
Yes, madam, what? White common order dated 29/8/2020, passed today. Pass order dated 29/8/2023, that is today, passed in WP number 21268 bar 2023 and other connected matters has already read down rule 33B of the rules, right? Whatever rules, full stop. Paragraph. For the reasons assigned by us in the aforesaid common order, it is directed that in case petitioner produces residence certificate issued by competent authority of the government of Telangana within a period of 1 week from today before the university, the petitioner, the university shall treat the petitioner as a local candidate for second round of counseling. Right?
Already we treated, your seat was allotted.
Right. So shall treat the petitioner as a local candidate, full stop. Needless to state that the claim of the petitioner as local candidate for admission to MBBS stroke BDS course shall be considered as local candidate for the academic year 23-2024 as per his merit.
Yes. Deeply applied. Page number 28, I filed the local certificate as well along.
We are not the university granting admission.
Yes, ma'am. Deeply obliged.
Accordingly, the petition is disposed of. Madam, get this order typed now and give it. In another case, it is required. Accordingly, the writ petition is disposed of. Please have Mr. Rao.
Copy by tomorrow, Your Lordship. So that.
Today?
Yes, ma'am.
This is which case, madam? 56.
Deeply obliged.
May I please, members? Yes, please. May I please, members? This is the public interest litigation matters which is
counter.
Allotment of counter has been
Counter is filed, my lord. They want us, they are seeking leave for withdrawal, right?
So public interest litigation, so you cannot withdraw.
Not.
No. My lords, the counter has been filed, my lords, by them. My lords, basing on the counter, this may be disposed of, my lords. Basing on the counter filed by Advocate General, my lords, this may be closed.
What is the counter, Mr.
My lords, counter is, my lords, this is in fact, my lords, transferred by Yadagiri Gupta Temple Development Authority.
Counter.
My lords. It's virtually in exchange of the property, my lords, the trust.
In this petition, which mark the presence with consent of the parties, same is heard filed. In this writ petition, petition filed as public interest litigation, the petitioner inter alia seeks petitioner inter alia assails the validity of action of Yadgiri Temple Development Authority executing a registered sale deed dated 5/9/2019 in respect of land measuring 2.30 guntas of survey number 172 situated at Gundalapalli village, Yadgiri district.
What, so then can we go, they exchange it because they, the government,
Everything we can put para 4 and 5.
it is only exchange for the nominal value,
Fine.
but taking the cost of
All
construction.
right. Has the respond number 4 in para 4 and 5 of the counter has taken a stand which is extracted below for facility of preference, paragraph 4 and 5. Right. Thus it is lying below. Thus it is evident that the land, that the allotment of land has taken place
In exchange of
an existing land,
Existing building, my lords.
existing building belonging to
Trust.
belonging to Yadgiri, no, belonging to respondent number 6, this namely so and so.
A consideration for land also is paid, my lord, 16 lakh and all. In addition to that, 16.50 lakh, there are 6, my lords.
In addition, the consideration for exchange is 16.50 lakhs.
Yes.
Full stop. Full stop. Therefore, what you submit, it be disposed of.
Yes,
In view of aforesaid stand taken by respond number 6, learned counsel for the petitioner submits that the writ petition be disposed of. Paragraph. In view of stand taken by respondent number 4 in paragraphs, aforesaid paragraphs, it is evident that the action of executing a sale deed cannot be found fault with in the facts and circumstances of the case. Accordingly, petition is disposed of, dismissed, disposed of, disposed. Yes.
Obliged.
Obliged.
Yeah.
Lord, it's ready. Lordships, today morning I have filed a reply, my lord, will along with substantial material papers. Kindly activate 230, my lord. Kindly activate 230.
But my lord's order on 24/8 was recording my submissions made. The lordships directed me to file an affidavit. I have filed an affidavit incorporating the statement which I made before my lords. But
what he has filed, we don't have the benefit.
now he has filed just now. I served a reply.
Day after.
Yeah.
Mr. Prabhakar, learned counsel for the petitioner, submits that today what you have filed?
Reply affidavit.
That he has filed a reply affidavit today. However, same is not on record. Office is directed to trace the same and place it on record. List on tomorrow or day after? Tomorrow is what?
Thursday.
Better. Friday. List from 1st September 23.
Oh, please.
Keep your bed.
This matter.
Counter Mr. Mayur Reddy.
Yes, we have
The revenue we have filed.
I filed a
The file on behalf of the revenue.
You are appearing for whom, madam? We will means we don't go. Learned counsel for respond number 2. Grace fund is granted 4 weeks time to enable her to file counter. Petition is admitted for hearing.
May I submit? In fact, I am in position, but that may have to 2 weeks. I purchased it subsequently in the year 2019. Allotment was in the.
We have only granted them 4 weeks time. What they do is installments 2 weeks now. Then again it will come up. Then again she will say 2 weeks. So we have at one stretch, we have granted 4 weeks and we have admitted the petition. It will be heard. If you want to file counter, please file.
My counter is being filed today. Correct. The only problem is the land has been purchased by me.
No, there is no interim order, right?
There is an interim order.
What? So you have please file a vacate petition. We will consider vacate petition.
Like that. Interim order is there. Lordship's interim order is intact.
Intact, no? Of course, intact.
Yes, I'm sorry.
If you don't say anything, it will remain intact till he files an application for seeking vacation.
Because only
please file. We'll consider.
DP of that.
I'm representing for respond number 1 to 5, Your Lordship.
Who said that I am vacate? I don't
Additional counter affidavit is filed by respond number 1 to 5, Your Lordship. Earlier, Your Lordship, counter is filed and Your Lordship directed us to file an additional counter. What measures we have taken to prevent the lumps?
When?
Law petition, Your Lordship, on 2nd August, Your Lordship directed us.
Additional affidavit.
We have already filed, Your Lordship.
When, madam?
28, Your Lordship. 28/8.
Some order we had passed, no? Where is that order, madam? Order sheet not there. Control and prevention.
Lumpy skin disease regard to the animals, Your Lordship.
So which are these 2,117 institutions? Para 4. Awareness program where organized.
Surveillance engaging the
In
services.
compliance of the order dated, right, madam? In compliance of the order dated 1/8/2023, the respondents have filed an additional affidavit on 28/8/2023. In the additional affidavit, it is stated that that goat pox GOAT pox POX vaccine has already been administered to 30,96,433 cattle by the end of January 2023, and again a vaccination drive has been initiated from 1st of August 2023, and a total 5,25,049 vaccinations have been administered. Have been administered, full stop. District wise, they should give.
Even on the same complaint, the Lokayukt also closed the complaint, Your Lordship, that we
District
have.
wise, you should give us details.
Yes, Your Lordship, the details are.
The petitioner, the respondents have for the paragraph, sub-para. The respondents have further stated in the additional affidavit that 2,117 institutions have been involved for prompt detection of new cases of LSD in animals. Full stop. It is further submitted that awareness programs are also being organized on the general sanitation and biosecurity measure in each and every farmers meeting. However, the respondents have not disclosed the figures or district wise figures of
That was, Your Lordship, the same complainant filed a complaint before the Lokayukt, Your Lordship.
district wise we want.
That was filed at page number 8, Your Lordship.
8.
Lokayukt order is on page 7, Your Lordship. Periodical reports were given.
Sunita, these are camps what we have held.
Yes, sir.
What we are asking is these 2117 institutions.
Yes, sir.
We want district wise list.
That will provide, Your Lordship.
It is what my lords are saying.
We can cover the district wise. So like, and these things, these are vaccination district wise. There. However, the respondents have not given the have not disclosed the details of 2,117 institutions which have been engaged for prompt detection of new cases of LSD district wise. Let an additional affidavit in this regard be filed, including the measures taken, latest measures taken up to the date of filing of the affidavit, be placed on record by filing an affidavit within a period of 8 weeks.
Much obliged.
List thereafter. Yes. Yes. Huh?
It's both matters.
Fixing a date.
61, 61, 62 both.
Old matters.
Common issue.
Huh?
Arising out of the same, security.
No. What did you say? Old matters.
No. But a common issue with regard to same essay arising out of. So.
What have you challenged in this?
In this IA order by the DRT, rejecting my application to send the documents. Promisor note guarantee, having posed, etc. Contention and application was fine.
No.
For the DRT along with the application, which was rejected.
You wanted the documents to be sent to?
FSL, Government Forensic Laboratory for examination. Because contention is that she executed a document with regard to registered mortgage, but guarantee concern she has not stood as a guarantor. She has not executed.
You have executed a mortgage deed?
Mortgage deed.
But not a deed of guarantee.
Guarantee. And the mortgage deed also, in fact, there is some contention raised only for the 5 crores. They have increased to 32 crores. That's etc. That will be bleeding in the essay.
Why are you resisting this prayer? Are you?
I'm appearing for the bank.
Are you resisting this prayer? You are all like instrumentality of state. You are being constituted for benefit of public, right?
That may not.
No. Are you opposing this sort of an innocuous prayer that it should be deed of guarantee should be referred for forensic science?
My submission is that it may not be required. But the Lordship may kindly hear me for
No, but she petitioner is not admitting. You are not relying on deed of guarantee, therefore it is not required.
We are only relying upon deed of mortgage. The security.
Correct.
But if they are not relying on the promise of guarantees, your Lordship may say one. I've asked for the following documents. I asked for the documents, your Lordship may kindly see.
Which document? Page
31.
31. Where are the documents? No, not
these documents to be referred.
30. Page
31. 31.
Where are 30? No list is given 31.
31 below. 30.
Para 4, 5, 6, 7.
I'm sorry, I think Your Lordship have taken item 61, 62, Your Lordship.
No. So obviously we will take 61 only because 61 has been called.
I'm sorry, 62, 62 is not.
No. So what 61 you are not pressing?
I'll just tell about
Then what is?
62, the order is there. 62, Your Lordship. I'm sorry. Page 31, Your Lordship. Pyramid starts at page 26. 31 is the documents to be called.
This everything you are saying. Like very good. All no.
To be compared,
Lighter vein we are saying. All the borrowers should take feel inspired from you. Execute the documents, avail of loan, don't repay, and then say all cases say that forensic science the bank is a fraud. It does not exist. And I have not taken loan. Obviously, you have never taken loan. The question of repayment does not arise.
She is not the company has taken loan.
Mister, one thing, the order is passed by the DRT. Under which provision?
DRT has got a provision.
Which provision?
Section 22 of the DRT.
So appeal lies under section 20.
At that time, because the presiding officer was not there, we filed return appeal.
Now the presiding officer is there.
Something to what they say,
Satyavati Tandon and this thing, it's binding 3-judge bench. Consistent view, Mister.
Yes, right. I have said in
senior counsel, you have a duty to be fair to the court. Every case we are taking the view that Satyavati Tandon file. If there is an interim order, we will protect you till you file an appeal. That will continue till you file an appeal before debt recovery appellate tribunal. Which is the interim order? No interim.
Subject to what they say, my only submission that Your Lordship, not the matter for reconsideration. The bill is not properly done.
No.
Subjectively. If they agree, Your Lordship ask.
My submission is this. They are not disputing their signature on the memorandum of deposit of title deed.
No, Mr. We are not entering into merits of the case.
10 minutes. They
are not agreeing. So 26/6/19 order will continue for 8 weeks. You file an appeal before debt recovery appellate tribunal. We will direct the appellate tribunal to decide the appeal on merits.
I have a signed submission to this.
No submission. This order is subject to challenge in Supreme Court.
The stay is not on SATVC proceedings, Millets. The stay is on the proceedings in the SA, Millets. There is no stay with respect to SATVC proceedings.
Whatever is the interim order shall continue.
Very well.
And in any case, you have a right to file 136 article SLP.
Millets, I have not intended to challenge.
No, you should file. No. How will bank generate litigation for you? They should know. They have to be kind enough to you to generate litigation. You will go to Supreme Court, argue there. That High Court grossly erred in following Satyavati Tandon law laid down by your lordships. That should be the ground of special leave petition. That High Court grossly erred in following the law laid down by 3-judge bench of Honorable Supreme Court. What, Mr. 61, there is no order, interim order. Is there any?
Also, there is an order.
All right, whatever. Yes.
This,
yes, fine. This mark the presence with consent of the parties. Matter is heard finally. In this writ petition, the petitioner inter alia has assailed the validity of the order dated 17/12/2019. Mr. This is passed under 14 of surface.
14, section 14. The other is under
passed under section 14 of the SURFACE Act. Right, whole thing, 2019. Where is that order, brother? That we had this thing.
27/12/2019, page 19.
Dated 27/12/2019, passed by the Chief Metropolitan Magistrate under section 14 of SURFACE whole thing. Act. Admittedly against the aforesaid order No, this is appeal. Admittedly against the aforesaid order passed under section 14 of the Act, an appeal lies before the Debt Recovery Appellate Tribunal. The
Debt recovery tribunal.
sorry, Debt Recovery Tribunal. What is the judgment? We have
This is 17.
Yes.
This is 17.
this I have, but we had that order, no? No, Satyavati Tandon you have, but against an order passed under 14, an appeal lies under section 19, Sham Sundar. Full stop. Admittedly against the aforesaid, 1 minute, but don't write. What have you written? Debt Recovery Tribunal under section 17 of the Act, in view of law laid down by Honorable Supreme Court in Bajrang Sham Sundar Agarwal versus Central Bank of India and another 2019 within bracket 9 SCC 94. Paragraph. The next para of this thing, para 5. Honorable Supreme Court in Satyavati Tandon has deprecated the practice of High Court in entertaining the writ petition despite of this paragraph, madam. Paragraph 5 from WP number 20342 of 2023. This thing. Paragraph. In view of aforesaid enunciation of law, we are not inclined to entertain the writ petition. Since a bench of this court, while entertaining the writ petition, had granted an ad interim order on 2/1/2020, it is directed that the same shall continue for a period of 8 weeks. However, liberty is reserved to the petitioner to take recourse to the remedy provided to him under section 17 of the Act. Line below, with the aforesaid liberty, the petition is disposed of. What?
This is challenging criminal MP that has become infractious because I have to file a fresh. The warrant has already expired long ago. Now I have to file a fresh criminal petition under section 14, so that order may not be required in this writ petition. The other matter, which where they are.
If you face infractions, your lordship assist.
Delete.
Bank has report. Respondent has report.
Delete. This petition has been in this petition. What have you? Please read, madam. Next case, madam. WP number 19376. In this writ petition, the petitioner has assailed the validity of the order dated 20th August 2019 passed by the Debt Recovery Tribunal under section 17.
Under section 22 of the DRT Act.
Under section 22 of the DRT Act 1993. Section 22 of the Recovery of Debts and Bankruptcy Act 1993.
Yes.
Full stop. Admittedly against the aforesaid order, an appeal lies under section 20. Under section 20 of the Act before the Debt Recovery Appellate Tribunal. Right, madam? Then para 5 of that judgment we told. Paragraph. However, a bench of this court, while entertaining the writ petition, had granted an interim order on
26/9/2019.
26/9/2019, the same, the aforesaid interim order shall remain in force for a period of 8 weeks. The petitioner is granted, however, the petitioner is granted the liberty to file an appeal under section 20 of the Act before the debt recovery.
Section 18 of Surpass Act, subject to correction.
You said 93 Act and then you are saying that.
Right. The powers of procedure will not follow. Under the Surpass Act, Section 18 of Surpass Act.
Section 20 also 93 Act provides for an appeal.
That is well under an application under Section 19 of that Act.
What have you written, madam? Read again. No.
1/8.
Wrong.
I think they will not also do so.
Beginning. No, before that.
Section
20. Appeal lies under section 20 of so and so Act.
In this petition, the petitioner has succeeded in private property.
Under section 22, no.
Order is passed.
No, read again.
Order is under Section 20 of DRT Act. But the appeal lies under Section 18 of the Surpass Act to the
Admittedly against under section 18 of the SITI Act 2002. Then this is the only correction. Before the debt recovery appellate tribunal. Debt recovery appellate tribunal. No, not Satyavati Tandon. This order, madam, order passed in WP number 2034 of 23. This is not Satyavati Tandon. This is our order, para 5. In view of aforesaid enunciation of law, after quoting para 5. In view of aforesaid enunciation of law, we are not inclined to entertain the writ petition. However, the bench of this court on 27/9/2019 had entertained the petition and had granted an interim order. Full stop. Therefore, it is directed that full stop. The petitioner is granted the liberty to file an appeal before the debt recovery appellate tribunal within a period of 6 weeks from today. Needless to state that the interim order granted by a bench of this court shall continue till for a period of 6 weeks from today to enable the petitioner to file the appeal. It is made clear that this court has not expressed any opinion on merits of the case. With the aforesaid liberty, the petition.
Plus.
What?
I don't have to make representation. You are not slave. You are not planning price to
Representation?
with regard to our payment. Once we are only saying
They are up.
to give 2 days, but
No, they will. No, because
it is their interest. I know, but
because then what happens that in case they don't fight, then they will file extension and all that. Or, you know. Yes.
Obliged. Wait, please.
NCC candidate, some we have done, no?
My lords have modified the order at their request.
Modified the order.
Yes.
Lordship modified the order.
Originally, my lord, the direction was that.
It has been modified.
Yes, originally the direction.
Now why it has come?
He made a request, my lord.
I made a request because the admissions are coming up. But he claims what he.
No, correct, Mr. So which modification, where is that order? Please tell us. It has already been modified.
Yes, my lord. At his request.
In this petition.
Yes, my lord.
Then
the order, Lordship is not. I did not take the copy.
23/8/2023 order.
Yes, my lord.
23/8/2023.
They said as and when the counseling is happening, their cases will be considered.
The interim order insofar as it directs admission into first MBBS course is modified. However, petitioner shall be at liberty to approach this court with regard to grievance of medical admission and as when date of counseling NCC seat is notified.
On this, Lordship, kindly say second phase of counseling, they are going to consider all the cases. That if you produce a certificate was
So this has to be heard according to you.
It has to be heard.
Have you filed counter?
Will be filed counter. And vacate also. To file counter as well as vacate.
The submission was, my lord, they are not going to undertake. Now, my lord, they say they are undertaking, but I am ready, my lord, subject to my lord's convenience. I am ready to argue the matter.
Mr.
Now, with respect to the state, we have filed a formal.
You are there, why? See, additional advocate
general is already on behalf of university, my lord.
You are not appearing. You are appearing for state, he is appearing for university like this.
Blood is playing in Lord a writ of mandamus, directing the state to let the incorporate the reservation.
That can't be done.
That's the
No, no.
That's my kindly see the relief.
But the rule is under challenge. The state has to sustain, my lord, the challenge. The university has no say in the matter.
1 minute. When are you starting? As an officer of the court, he can address. We can appoint him a Microsoft.
Yes, my lord. Yes.
So, Mr. Rao, when the second round of counseling is starting?
After tomorrow, NCC. The date is not yet fixed. Therefore, notification will be issued. 1-2 days.
Wednesday.
Tomorrow you will have bats. So with that, tomorrow we'll have floodgates open for the in the gates. No. This is focus. Nothing else. There will be fresh masses. So we'll hear tomorrow.
Petition list tomorrow. Tomorrow we will hear.
Tomorrow.
Give a synopsis.
Yes, but and in fact, I am ready.
Conclude within.
May I make a request? Tomorrow and day after, my lord, I have personal inconvenience. My lord, any other day other than tomorrow's day after, I am extremely sorry. My lord, today I am ready. I can only request.
Mr. Don't then this thing then say that it is being done and admission.
No,
you are speaking in adjournment. We are ready to.
I am not saying I am ready.
This is Mr.
Yes.
This is taking into account the real possibility of your case being taken up, right?
Yes, well, I understand.
That's why we said tomorrow, because tomorrow we have so far 54 cases only. So we thought that we will take up your case.
Very well.
Now you want it on Friday. The bench is till 1:30.
Tomorrow, your lordship posted to.
Please appreciate us.
Yes,
For the interest of these students, we are not getting admission in his university.
But it's all their own doing. I'll demonstrate. I'll demonstrate tomorrow.
That the only request to use, Mr. Counsel, please prepare a synopsis. Be brief.
I will.
It's not like review of Keshwanand Bharti.
No, it is not. I have already
prepared a synopsis, and this thing we will hear Mr. Rao what additional AG has to say. I don't think he has much to say when Mr. Rao is arguing.
Meanwhile, in this matter, the counter from third respondent is required.
I received just 2 days. I will get it here. Yes.
We are taking it up tomorrow, Mr. Kumar.
Tomorrow, I'll try to get it, but the draft form.
Please get it. Mr. We will be the happiest person to fix it on Friday and sit till 1:30 and say number not reached, and then it goes for Monday. We no. Why we are insisting? We have told him that argue tomorrow despite his inconvenience, because we want to decide it genuinely.
Yes.
Otherwise, we will give a date where we have already fixed 82 cases, 6-9. It will never reach.
Yes.
We will be happy.
At his request, my lord, your lordship granted time on the last occasion and no problem.
Tomorrow, I'll get it duly signed, but otherwise the draft form is ready.
The only thing is day after tomorrow is Friday, Mr. Friday, no?
No,
Thursday. Today is Tuesday.
Thursday is
30th, 31st, maybe.
31st?
My Lord, my nephew is getting married on 31st. I'm extremely sorry, my Lord, I cannot attend. That's why I said, my Lord, tomorrow and day after.
But otherwise, that's it. I'll get in synopsis, my Lord, so that Lordship can, instead of counter on this, my Lord, I'll synopsis.
Hardly you have hardly anything to do. You can support Mr. Rao.
My Lord.
Huh?
Tomorrow I'll get it.
You are supporting Mr. Rao.
My Lord.
It is they who have changed the policy of reservation, my lord.
You are appearing Mr. Rao in these cases, no?
Government is, your government is.
No, but you also appear.
I'm also.
Please appear. We will appoint you a amicus.
University is a party right here.
University is a party.
Yes, yes.
My second best.
So we will hear you, Mr. Rao, in these cases before whatever additional AG has to say. We will hear you, and if you are not there, we will appoint you as amicus. Say that you are not party.
And my party, my Lord, I will appear. My Lord, the Advocate General also, my Lord, I will appear, my Lord.
No, he is appearing additional advocate.
Yes, Lord. But
Advocate General will appear.
I am an additional advocate, I am myself.
No, you will argue, right?
Yes.
Not Advocate General, he is.
Yes.
But we will hear you also. You are the one who has defended, government didn't argue the bunch today. We have delivered the judgment. That's why he has taken on everybody single-handedly, and most of his submissions have been accepted except rule virus.
But I failed, my Lord.
Not failed. Mr. Rao succeeded. Interpretation of rule, none of the petitioners fall under that capacity, this thing, this category. This you have succeeded. You have said that full bench, the court has interpreted the rule. We have held, yes, full bench interpretation is of great help to us in interpreting the rule. All submissions, if you read, we have accepted. List on who prays for adjournment? Mr. Praveen Kumar undertakes to produce a synopsis on or before next date of hearing. List on 31st August 23.
Lord, 31st, my Lord,
Oh, sorry.
I'm sorry for marriage.
30th August.
Yes.
30th August.
Yes, yes.
Oh,
I'm sorry, my Lord.
tomorrow.
Yes.
Tomorrow. Sorry, I didn't realize.
Next items.
So 63 to 66, everything. Please supply, Mr.
అది అవి ఆ కేసుల్లో ఇందులో రాలేదు పదామా
Item 16, item
67 to validity of rule challenge. Validity of rule is under challenge, right?
Yes. But in fact, this matter was carried to Honorable Supreme Court, my Lord, in 2018, and we have filed an expedite petition in 2018 itself, my Lord, for advance hearing. Because the rule was under challenge, and several of the petitioners, my Lord, were not allowed to participate in the recruitment process because they were made ineligible by virtue of the rules.
No. What are you saying? That the matter is pending before Supreme Court?
No, my Lord. We have approached the Honorable Supreme Court, my Lord, directed us to make a request here. In view of the request, we have filed an IA here, my Lord, for expediting the hearing of this.
Where is the order of Supreme Court?
Right, it's filed in writ petition number 1353.
Where is the order, Mr.? When that order was passed by Honorable Supreme Court? When?
18. We filed an IA in 2018 only.
What were you doing till 23? I have only joined 5 weeks.
So, my Lord, it was always getting listed, my Lord, but because of the probably city of time and administrative reasons, my Lord, it was not being heard. Well, we filed an IA in 2018 itself seeking for expedite hearing. It was getting listed, my Lord, but it was only that couldn't be heard because of paucity of time. But now what has happened, my Lord, the
issue with regard to validity So it will be heard.
Now what has happened, my lord, the state has issued a new notification. They are coming up with a new notification relying on the same rules. Again, it will be the same problem. So there is a little bit of urgency, as your lordships may kindly be taking that into consideration.
In this batch of rate petition, comma, validity of rule 4 within bracket Roman capital 2 within bracket small Roman 2 of what rules of
Teacher recruitment test rules.
of which is the name of the rule you don't know?
The teacher recruitment test rules. GMS number 25.
The Telangana direct recruitment for the post of teachers rules 2017. That's correct that you did not even knew the name of the rules. So you should have read it from. When we write in the order sheet, it has some sanctity, mister. We cannot write teacher recruitment rule like you. The Telangana direct recruitment for the post of teacher rules 2017, right? Full stop. No, how many this thing? So any of the petitioners have secured? So those people go out, right? They are selected. No. Arey, mister, you didn't get it right. We didn't ask you who is selected. We told you which of the petitioners have secured minimum cutoff marks in each of the category. What? Give the names.
My friend has given me. My clients have secured more than minimum marks.
All right. Which your client means which
WP
case?
number 9164
Then,
of
Madam, write in
2019.
compliance of the order dated 10/4/2023. The Telangana State Public Service Commission has produced a statement indicating minimum cutoff marks in each of the category. Full stop. Will you give a joint statement like both
petitioners in one writ petition who have secured more, who have, so. No, in this entire 26, there is not.
These petitions will go, right? The details of the petitioners are as for, the details of the writ petitions are as follows. Quote 26, right? Paragraph. In view of aforesaid subsequent event, comma, the said writ petitions are disposed of.
My lord,
Writ petitions number so and so are disposed.
but they have only given us the document. I'll just narrate, my lord. Serial number 43633. This is matter pertaining to physical education teachers. Cut-off marks do not have any.
Then why have you got yourself in bunch?
I'm sorry.
Why did you get yourself in the bunch? Then it has no relevance then.
No, my lord. Now, by saying that we are not having the cut-off mark, that will not have a relevance.
So, madam, in the bunch you write WP 4343633/2017 be de-linked from the bunch and be listed separately for admission. Right.
My lord,
So, 1 minute. Then other cases, following petitioners 1, 2, 3 delete, his case has been de-linked. Remaining cases 4 to 26, right?
I'm extremely sorry.
These writ petitions.
I'm extremely sorry. In matters, my lord, what has happened? I'll just narrate 2 minutes.
No, you are appearing in all the cases.
Yes, my lord. Around 22 matters are in my name.
So then he says, 1 minute. Supposing if he makes a statement that the petitioners have not got the cutoff marks, right? So what is the effect on the challenge? Is he correct in saying that those petitioners lose locus to continue the petition? Correct or not legally? Then we will see.
My lord, I may only permit it, my lord. 2 aspects, my lord. They have given the papers just some time back. They said there are many not.
1 minute, mister. What we are trying to understand, is he correct in saying that the candidates who have secured marks below the cutoff marks are not entitled to further prosecute the petition? Is he correct in saying so or not?
Maybe, yes, my lord. Insofar as the other writ petitions, there are few petitioners who have secured more marks.
That those he has separate, those will survive.
That in the list which is placed before your lordships is mixed with
Which
all
case?
the writ petitions.
No, he is saying it is signed by assistant secretary. He will be hauled up for contempt, misleading the court. Please understand, it is duly signed by the assistant secretary stamp. Are you disputing this?
Yes, my lord. My lord, I'll just say 43768. In 43633 and 1111.
No, one
My lord, there is this, my lord,
double one. We have double
my lord, there's physical education teacher matters where minimum cutoff mark is not the criteria. It's
So we will de-link it, Mr. We will de-link these 2 cases. And what about the remaining 2 matters in this list?
In other batch of matters, my lord, the Honorable High Court, my lord, did not permit them to write the exam. What the Honorable Court did, my lord, is since I am not permitting you, selection and appointment.
What you are up to creating some confusion, right? Because we are about to we will continue. We thought that we were sitting so that we continue, finish it before 1:30 only. You are not permitting it to happen. So don't think that we will not be able to find out. We are coming back. We taken up at 2:30. And don't make incorrect statements.
Let them verify now with the list which are the matters which are not covered. So
you can verify now what are the matters which are not covered during the break and tell us that, Mr. You should be fair. I mean, duty, as I've been telling, we have been telling everybody, as officers of the court, you owe a duty to the court to be fair at all times. You will not get job in this, right? Even if petitions are allowed, you are not going to, you are an advocate of this court, you are an officer. So you are required to conduct the cases with amount of dispassion, right? Right? So therefore you must fairly tell that, sir, these 26 matters, these 2 matters are different, remaining he is correct in saying, or 4 matters are different, remaining 22 do not survive for consideration. This is what we are prepared to do it. We are not in a hurry to get numbers, nothing.
I did not have time to verify. They gave it just a few minutes back.
So you should say so, that I need time to verify. That is also understandable.
I'll get back to your lordships, my lord, immediately by 2:30.
2:30 you will be able to, then we'll continue. If you are able to verify, otherwise, you will verify?
I'll verify.
Okay. $230. You can smile at least.
Yes,
Nothing has been done.
my lord.
15 you have written, madam. Same order type in 16 and 17. Notice. Notice on IA, 1 of 23 and 2 of 23. Right? Both IAs notice. Same order. Yes.
Wait, please, my lord.
You appear
For the respondents, ma'am.
ready to take notice in anticipation.
I am appearing for respondents number 1 to 222, ma'am.
1 to
222.
222. And thereafter,
I'm appealing for a fellow
college.
no, which respondent, Mr. This intra-court appeal has been marked their presence heard on the question of admission. This intra-court appeal is directed against a bi-party interim order dated 7/8/2023, by which the learned single judge has fixed the fee, has permitted the petitioners to pay fee in the manner indicated in the order. Full stop. Paragraph. We have heard learned counsel for the parties. We have heard learned counsel for the applicant in the writ petition, comma, in the petitioners who are students of which year?
This year, my lords.
Law, the MBBS course. Which?
MBBS last year, ma'am. Postgraduate this year, 23-24 academic.
Who are the students prosecuting their studies in PG course in MD medicine?
Medical and dental, my lords.
In medical
and dental courses.
Postgraduate medical and dental courses had filed a writ petition seeking what relief?
I have challenged the.
No, what relief?
Set aside of impugned GOMS number 107.
Prayer.
Main prayer is set aside, my lords. And
where is that prayer?
You will find the prayer at page number
114. Had filed a writ petition.
114 it starts, man. 114 it starts.
It's not like 187 is your prayer.
187, man. 187.
No, you must be, that is this thing, appearing on a advance notice, and so that's why he is spared. He is very happy that court is not asking me any question. You are, we are treating you to be lordship. Yes. Students prosecuting the studies in postgraduate medical and dental courses. No. The petitioners in the delete, madam. The petitioners in the writ petition. The petitioners who are students prosecuting their postgraduate course in medical and dental courses had sought for the following relief. Had sought for quashment of GOMS number, quashment QUASH. They have not said so. Quashment of GOMS dated 28/7, GOMS number 107 dated 28/7/2023, issued by which respondent number?
First respondent.
No, who is one respondent number?
State of Telangana.
By state of Telangana. The petitioners by way of an interim order So, but delete. What was done by this GOMS? Delete, madam. Interim order delete. This prayer is this thing. Then the by said GOMS dated 28/7/23. What has been done, Mr. The state government has fixed the fee for
the block
fee
period
payable by
26.
students prosecuting postgraduate
Medical and dental courses.
medical and dental courses. In stop. The petitioners in the writ petition had line below. Petitioners in the writ petition had prayed for the following interim relief. Quote, page 187, 188. Paragraph. The learned single judge, however, after hearing the parties, comma, by an ad interim order directed as follows. Quote, interlocutory application is disposed of. Paragraph. This was 67, madam. This following direction 67. Take from 67. Right? They up to here, such refund. Paragraph. Learned counsel for the appellants submit that that in the garb of an interim order, the main relief itself cannot be delete. Learned counsel for the appellant submitted that the final relief cannot be granted by way of an ad interim order. It is further submitted that the learned single judge ought to have exercised a restraint in interfering with the impugned GO as it pertains to determination of fee structure. Fee structure. Alternatively, it is submitted that in case the learned single judge was of the opinion that the fee structure fixed by the state government was arbitrary, comma, it would have remitted the matter for consideration of a fee fixation committee. Full stop. Paragraph. In view of paragraph, the appeal is admitted for hearing. Notice on behalf of respondents number 12222 is accepted by Mr.
Sandeep Reddy.
Reddy.
I've given the slip.
And what then 223 to GP 223 GP medical, then 224 Mr. Prabhakar Rao, learned counsel for 224, then fee regulatory committee for 225, then 231 and 232. Then issued notice to remaining respondents. In the meanwhile, operation and effect of learned counsel for respondents may file counter to IA number 2 of 23 if so advised within a period of 2 weeks. In the meanwhile, operation and effect of the impugned order shall remain in state.
My lord.
Till next date of hearing.
My lord, now.
Then beginning you write, madam, IA 1 of 23 for reasons assigned in the application duly supported by an affidavit after appearance, right? Requirement of so and so is dispensed with, IA is allowed.
My lord, one request, my lord, not stay by. This is ongoing counseling, my lord. Fees has to be paid now. And the division bench judgment of this honorable court has not been followed, my lord. This honorable court has held.
No, but Mr. Tell us that how by an interim order the court can fix the use of the jurisdiction of a fee fixation committee. That's the issue.
My lord, this is only an interim order, my lord. And for a minute, Lord, may kindly hear me. There is a division bench order.
We will hear you, of course, because number one, that's why we ask you, you are not on caveat, right? You should have filed a caveat. You would have thought that they will not leave you. They will not leave you like this.
I'm already served with.
You are not caveat. You are only appearing on advance copy. File a counter to this.
My lord, to the question that your lordships posed of how can this honorable court fix, there is already an interim order passed by this honorable court, first division bench, my lords. Same fees for a different block period. Your lordships will find that order at page number for lordship.
Where is that order?
Lordship, may kindly see page number.
No. Where is it referred to in the order impugned in this petition?
It is referred to, my lords, everywhere it has been, GOMS number 20.
20 has been referred to.
The learned single judge has, lordship.
And they fixed my imprimatur in the courts. They said that the same system it was followed, that's why we get 6 pages.
Mr. This fee was fixed for previous years also by an interim order of the
Same
court.
fees, my lord.
No. By an interim order of the court.
Yes, my lord.
No, this court, this learned single judge of this court last year also fixed the fee.
Not single judge, my lord. Your lordship's first division bench has passed an interim order. Same.
Where is that?
Your lordship will find the interim order at page number. For a minute. 449 it starts, second volume, your lordship will.
So, Mr. We will consider your appeal.
Very well, my lord.
Still let them file counter.
Yes.
Let them file counter.
My lord, only submission, my lord.
They will not run away, right?
Very
Correct.
We are studying in those colleges, my lord, subject to outcome if your lordship.
Remaining amount you can furnish bank guarantee.
That is what I think the.
Bank guarantee is already there, my lords. We are already furnishing bank guarantee
No,
for the
they
remaining
will have
fee.
to pay 60% of the amount.
Lordship. Lordships, next 3 years, the petitioners are going to be in this college only, my lords. They are not running away.
You're not at flight.
They have already issued a bond. Lordship.
Not at flight risk.
No, not at all. This is PG medical and dental courses, man.
We understand. And, see,
Well, similar
One minute, one minute.
given at page 68, my lord, they have to give a bank guarantee.
admitted for hearing, right? Huh? Then don't meanwhile delete. Learned on the other end, his submission, right? On the other end, learned counsel for respondents submitted respondents 1 to 222
Yes, sir.
submitted that a division bench of this court, which order?
Your lordship will find the order it starts at 400 and.
No, date of order. Division bench of this court by an order dated 26th May 2022. 2020. Last year you said this is 20 petition.
Immediate before block period.
Passed in WP number 6799/2020 has done what? Has fixed
Yes, my lord.
the fee by an ad interim order.
Yes, my lord.
It is further submitted that the aforesaid interim order has been taken into account by the learned single judge while passing the impugned order. Paragraph. Let counter, if any, to IA number so and so, which IA number 2 of 23 be filed within a period of 2 weeks. List the aforesaid IA for consideration.
Document
The counter is filed.
Document is not staying there.
Not staying.
Very well. Oblige.
We will hear you.
Oblige.
We have deleted that portion. Meanwhile, delete.
I'm obliged.
We will hear you. Counter you
I'll
file.
file count.
Yes. Right. Notice.
That regulation committee, that is the only job to go out any period to get it. But
My Hasan, I got list of dates, got 5 dates.
Yes.
Short list of dates, got 5 dates.
Yes, but respondent rate petition. Then appeal filed by the law.
Yes.
Lord, 10/6/2021, my lord. First date, my lord. First date, my lord, 10/6/2021, my lord. A communication was sent to the sub-registrar by the revenue department, enclosing a list of prohibited properties, my lord. Lord, the petitioners filed a writ petition earlier, my lord, WP 8005 of 2023. Wherein, my lord, there was a direction to the registrar without going into the community, without, my lord, a reference to the memo dated 10/6/2021 of the property list to receive, register and release, provided it is in compliance with the Stamps and Registration Act. Lord, there is a circular issued by the registrar, my lord, by the IG and Stamps and Registration on 10/6/2019. See, for insisting of a no objection certificate, null conversion certificate, my lord. Lord, after presentation of the document on 28/3/2023, a communication was sent by the sub-registrar to the collector, But wherein the RDO had reported to the sub-registrar saying that these fake certificates have been produced by the petitioners are fake. But that is, my lord.
No, what is the grievance? You are still on facts. What is the grievance in the petition? Why did he file the petition?
But
And
for-
what single judge has done?
They want to register the document, my lord, belonging to the government, my lord, evacuate property. And they also want to register a bulk of land
So
of
what is the registering authority?
36,179 square yards. 36,179 square yards, my lord, they want to register, my lord, without producing the conversion certificate. They have produced the conversion certificate. On inquiry, found out to be a fake document.
So, an inquiry, what happened?
The
What are-
RDO had communicated.
No, you tell us. In fact, it has been. I always wanted to see. My lord must be aware. My brother must be aware that what are the guidelines like statutory provision which the registering authorities required to adhere to before registering a document.
Yes.
Which is it? Which provision, Mr. 22A of registration? Give Mr. What is 22A?
Registration Act. 22 speaks of prohibiting of certain government properties, my lord. But I am on the fact that there is a circular issued by the registrar IG, my lord, Samson registration, IG Samson registration. May I pass on the circular memo, my lord, issued by the registrar? It's not fine.
No, pass on means you did not pass on to learned single judge.
It is referred to in the refusal order. It is referred to in the refusal order.
You did not pass it on to learned single judge. Right? This is stop this practice.
One circular it was referred to in the.
Then you will say that I had handed over to division bench and division bench did not take note of it in SLP.
No, it was
Then
referred to and
SLP
extracted.
Supreme Court will say that go and file a review.
But referred to and extracted. But may I read the impugned order, my lord, in the writ petition first? At page 78.
No, this, Mr. This is 1 minute. Oh, we want to know the provision. 22A is not this thing prohibition. Where is what else is the registrar is required to do at the time of registration of a document? There are circumstances mentioned. 32.
32 is the procedure which the registrar has to follow
32. Yes.
when a document is presented.
32. Persons to present documents. It must be in the rules also. Rules it must be there. What all he is required to consider. Inquiry 34 probably. 34.3, Mr. I was looking for 34.3. The registering officer thereupon shall inquire see Telangana rules and registration must be there.
Apart from this, my lord, section 69, that is power of the Inspector General, my lord. Section 69 to make.
What is your grievance, Mr.? You please tell us what is your grievance. He presented the document for registration,
which is
that was returned by the registering officer. He filed a writ petition. Then learned single judges held that the document should be registered.
That order has a finality.
No, it's only an interim order. No, it's only an interim order. The first round of petitions was only an interim
What order you have preferred in appeal? Which order you have preferred in appeal? That's
at page 7, my lord. Page 7.
Close the file. Tell us you have read the file, right?
Yes.
What is the order?
Order to receive
just a minute.
Register the document.
He filed a document for registration.
Along with the converts.
That was returned by the registering officer, correct?
Yes.
Then he filed a petition. What has learned single judge held?
It was, he challenged the refusal.
The document, it is the general core of a topic, it is the same thing. My document is a GPA.
No. So what the learned single judge has done? It should be registered.
It has to be registered.
Registered. So why they have filed an appeal?
No.
No.
Not appeal.
No, Mr.
Without registering the document.
Probably we are not making ourselves clear. I wanted to ask. What is, no order to Mr.
Page 7 is the impugned order, my lord, where
You
repetition
are
has been
unable
allowed.
to tell Mr. GP for revenue what the learned single judge has done. He is saying provisional registration. You are saying no.
Directing the authorities to register the document, my lord. Page 12 is the impugned order.
Directed to process the document, registration and release.
Release the document. Basing upon the document.
No. So why, according to you, it should not be registered number 1?
It is a large extent of land which has not been converted into the non-agricultural land. The certificate so produced found out to be a fake document. May I refer to my lord's communication note of the.
That's it, right?
Yes. Please.
So which provision of law says that it should be a converted land?
26, my lord.
That's what we are asking. Rule
26.
26.
Every document shall, before the acceptance for registration, be examined by the registering officer, and to ensure that all the requirements prescribed in the Act and in these rules have been complied with.
This is the provision.
Yes.
I was. Yes.
May I refer my lord's attention to page
1
7.
minute, 1. On what grounds you had rejected?
Page 70.
What grounds you had?
Page 73, my lord. Page 73.
Under Rule 26, first tell us what is not accompanying with this document.
My lord, where is this making power, my lord? 70.
Conversion.
Lord, section 69, my lord, the IG is.
You said Mr. Rule 26.
Yes, my lord.
So where is this that conversion certificate should be there?
Conversion certificate is in the circular.
Rule 26.
Is in the circular which I have just passed on, Lord. By rule making power, my lord, the IG had issued a circular to all the registrars to insist upon the.
Mr. Just now, you referred to Rule 26 just now.
Yes,
and you are not reading it. We are looking at Rule 26. You are jumping to circular.
Yes. It has been presented in the proper office. Person entitled to present it.
No. Where does this rule provide that conversion certificate should
by virtue of a circular bill which I just now passed on, Lord.
It's not there in Rule 26.
No, my lord. It's only
Then why did you refer?
for the purpose of scope of inquiry. Scope of inquiry, my lord.
Use the court. Right.
Scope of inquiry. The power of the registrar to inquire into before presentation.
So he can inquire into that. Nobody is saying that he can't.
Yes.
He has to conduct an inquiry. We will modify that order that he shall conduct an inquiry.
It has been refused. It has been already refused. Challenging the refusal order, writ petition has been filed. In spite of that, my lord, writ petition has been allowed. In spite of the submission, the document is a fake document.
But how can it be found fake or what?
The authority,
see, Mr. Whether it's a fake document, I mean, the registrar decides whether any inquiry is conducted.
70, my lord, the concerned, the revenue department had issued a certificate to the sub-registrar. Page 70, may I read, my lord? Page 70. As per the revenue records, the land in survey number 297, extent of 19 acres 7 guntas, is classified as a vacant property. The then joint collector, without any authority, had issued allotment orders. The number referred to the
We'll hear it, Mr. We are issuing notice. Yes. Heard on the question of admission.
May I have one minute?
No, this is, you are on caveat.
As per our rules, the Makalat continues the return.
So you are accepting notice.
Notice that posing grant of interim order because there are.
We are not granting interim order, file objections. Heard on the question of admission notice. Notice on behalf of respondents is accepted by learned. Who is assisting you, Mr.? You are assisting him.
Yes, sir. Samir.
What's your name?
Samir.
Mohammed Samir. He prays for his granted 2 weeks time to enable him to file counter to IA. list thereafter. Initially, see, I have opened it. This is these people don't know it. Yes.
Pick up. By questioning the action of respondent four in not considering the order of the report. RJWP number 2.
Who is respondent number 4?
Respondent number 4 is the bank lordship. Already there is a common order passed in 2 WPs, 25174 of 18 and
No,
3412.
file contempt against them. How a fresh rate petition?
But the lordship, the order was passed, the sale notice was been set aside.
What
the relevant portion?
Which is the order under challenge in this petition?
No, we are not challenging the order. The order, the relevant portion, it is page 45. Lords. The common order.
They cannot cancel.
Options will be set aside, but in the meantime, so certificate is registered. So they will- in favor of the petition on sale, but they can cancel. They can, yeah, it is consequential to the.
You are what? You are a borrower.
Yes, Lordship. I have tendered my money also, that Lordship. The letters are been filed before the court.
No. So what happens if sale certificate is cancelled? The property comes back to you.
Yeah, that was the direction given by the ESEC Liberty to invoke 13.2 again. At page 45, Lordship, the single judge has observed that in 2 writ petition.
No, DB, it is DB, not single jet.
Sorry. Sorry, sir. I'm sorry.
They will do it right.
That's what. What is granted to them this month?
So what? I mean, they are committing contempt of this order, right? Violation of.
They are
this-
not deleting from the list of the
So
registration.
then file contempt, Mr. How a fresh rate petition? I mean, we don't understand. You are saying that directions issued by division bench are not being complied with by a bank.
Sale certificate was issued
Bank
during
is
the
a party. One bank is a party, right, to this rate petition.
Sale certificate was issued.
1 minute, one lot. We want to understand. Page 30, page whatever order 45. The bank is a party to this proceeding.
Bank is a party to the proceeding.
If directions contained therein are not complied with by a party, what is the remedy? File a fresh petition, seek another set of direction.
Now, meanwhile, the registrar is entertaining some registrations which has been effected in favor of the respondent of file lordship. The unofficial respondent who is now holding a sales.
So you tell us that according to us, I mean that you should file a contempt petition against bank for not carrying out directions. How a fresh rate petition you are filing? Please answer this.
Because the observations which has been made, he is not initiating fresh action, he is not accepting the money, rather he is.
No, so therefore the grievance says that the bank is violating the directions contained in the WP.
Yes, Lordship.
Then if it is so, then file contempt.
Yes,
Simple.
Lordship. I may permitted to withdraw the writ petition.
Learned counsel for the petitioner, after arguing the matter to some extent, seeks leave of this court to withdraw the writ petition with the liberty to file a contempt petition for non-compliance of the directions contained in the common order dated
This is 8/1/2020.
8/1/2020 passed in WP number 25174 and 34129 of 2018. Accordingly, the writ petition is dismissed as withdrawn with liberty as aforesaid.
I may be given liberty to.
We have given you liberty to file contempt.
Oblige.
Yes.
May present.
The petitions before your lordship that intends to recommend the enrollment as an advocate
Grieved by the instructions issued by.
Arey, Mr. Charges are confiscatory in nature. They are required to sell their property and pay fee for enrollment. This is the. What, Mr. You want to become an advocate and you don't have means to pay 57,000?
No, but it's against the.
Every day they ask,
In other petition, he knows that an argument was made before us that we are losing 1 crore per day because of our non-enrollment by the Bar Council. That petition we have heard. And here you are challenging 57,600. This quantum of amount, until unless you are able to demonstrate that it is confiscatory, no scope, it is beyond the scope of judicial review. Tell us, challenging for the sake of it is very good.
It is.
No, it should be, you are ideally speaking, you may feel that I should be charged a token sum of ₹1 per day or one at what this thing, and they should welcome me. That's fine. But what seems to you reasonable?
Only with one submission, madam.
Scope of judicial review is not this thing.
May I make one submission? A batch of writ petitions are pending before the Honorable Supreme Court in connection with this fees.
We will defer it. Which judgment?
Lord, I'm passing on the writ petition and the transfer petition now.
Kerala High Court.
Kerala, Maharashtra and Goa and Tamil Nadu also.
Mark the presence, learned counsel for the Bar Council is Telangana. What we have 100% is 7th September coming up.
100%.
Interim order.
Please, Your Lord.
Madam, interim order is, where is that 100% interim order? On or after 2/6/2000. Mr. Prabhakar, which case we have passed?
On 19th August, Your Lordship. 94, item 94.
Order. They are listed today. We will pass the same interim order.
Same order.
So, Madam, WP number. This is the order, right? That you can pass, right? You can type it just like this. Yes. 6/9/23. This same order.
May I request, my lord? The same facility, my lord. Yes.
No, you are appearing in which case?
27, my lord.
1 minute. We are at 22/23.
I'm sorry.
22 and 23, same order, right? I will give you just a minute, madam. 22/23, same order. Then 26 also.
24 also.
317.
100% reservation, 2626.
No, this year, written purpose. 27.
Yes, Mr. Rao. 27.
I'm sorry, my lord. In this matter, my lord 27, my lord GO, my lord 72 question. That this honorable court pleased to granted the order. My lord last portion, we have the four-side submission with view to maintain the party and for the reason that the same facility given the my lord by GO also. My lord only, my lord kindly see, my lord.
This is the interim order. These petitions, everything is coming up on 7th September. If you have seen this order.
My lord.
So it will, this is the interim order and it will come up on 7th. In the meanwhile, he will file counter and we will intend to hear. 7th, Madam 27 also same order, Mr. Rao. And then 28 also.
28 not. 28 is not.
28 is there. 28 is there already. Give Madam 28.
Uploading
30, 31, 29.
1 minute. 28 is similar, Mr. Rao.
28 my lord, this
Different.
registration.
After registering.
Different, right?
Separate.
Separate. 29, then which other?
29 same.
29 same.
29, 30, 31, same order, Madam.
34 lord.
And 34,
34.
same order. Huh? So like it's all same order. What are the numbers, Madam? 20. In which case 22, 23. 30. Yes, all same orders. 7th September. Now yes.
All the cases my lord posted on 6/9 my lord.
7th September. 7th.
Published.
7th September. He will file counter.
Published.
24.
6th my lord. It's posted on 6th.
24.
Batch matters posted on 6th my lord. 6/9.
6/9, whatever. 6/9. Whatever is the date it comes.
Yes,
up, that day. Yes.
Seeking direction without.
1 minute. This let 24 be called. We will come. We have passed orders in 24, 27, 29, 30, 31 and 34. Same order coming up on 6 September. Further date of.
My band is 28.
We have not yet called, we are at 24 now.
Yes, please.
Lordship, one humble request is, order copy may be, interim order copy may be made available by tomorrow. Obliged, deeply obliged.
Item number 24, my lord. My lord, the petitions complaint before your lordship.
PCB is not taking any action
Yes,
and we are imposing,
My lord, they-
now we are
it was
imposing.
plundering the nature.
One
My lord,
minute.
yeah. I leave it.
You are not taking any action. People are flocking to this fort, right? And you are apart from you are competing with the state government in generating litigation, right, Mr. Your officers all the time keep on sleeping, and when they only wake up to engage you.
But with your
No, it's a serious thing, Mr. All this thing petitions like why he is coming here. That I made a complaint. That complaint may be correct, may not be correct. God knows. Your officers will know. And this thing. But you don't respond. Why should you not respond? Tell us.
With your lordship's permission, my lord, in this matter, what had happened is multiple representations have been given over a period of time. Action has been taken. Some of
Where
the
is
reports
this?
are some of the reports are also
All right. Learn it. Yes, in this 1 minute. We let him file a report. In this.
The cabinet secretary making a party with references. Not even a single reference to the environment.
Yes, Mr.
My lord,
And the file conference will have
like to make two submissions. I'd like to make two submissions. But it's a fact that we have been presenting representations. The board is doing an IWAS job. But they consider, they pass an order. Again, they allow the very errant company to go ahead with the pollution. That is the problem.
No.
It makes 75.
1 minute. First submission is, their submission is that why have you Union of India through Cabinet Secretary? What is this sort of impleading? So you will have to correct the cost title, right? You will have to learn it counsel for the
I could have avoided.
under To do it today, just now, before leaving the court hall.
Yes.
Just now. Learned counsel for the petitioner undertakes.
Mr. Rogers, permission, my lord. In fact, the company against which these allegations are being made, the matter is currently pending before the Honorable NGT, my lord. Subject to your lordship's decision, my lord, OA 97, my lord. In fact, some of the orders are also filed in this. The very same company, the matter is being adjudicated. We leave it to your lordship, my lord.
Lord, this is one.
No, all oral submissions we should like. Will you not mention it so that he knows? He is resisting every attempt to go to Chennai. He wants to go to Delhi. You are sending him to Chennai. It's like this.
No, my lord. I would make one small submission.
No submission. He will file a status report with regard to action taken on your representations. Correct?
If
this is only entertained. Ideally speaking, you should go to NGT.
Well, an humble appeal,
if he says so that this action against the company you are seeking is before NGT, we will have to relegate you to NGT. But we want a statement on affidavit.
I want to make one small submission and leave it to your lordship. For your lordship's discussion. My humble submission before this honorable court is this. This is the game played by the 9th respondent.
No. So they should be hanged right away.
No, I am not asking. I am not asking.
35.
No.
Game.
My appeal.
Mister, please understand.
Let there be.
Please understand. We are asking them to file a status report.
Pleasure. I thought I could make one small request.
You thought that the petition is being dismissed, right?
No.
That you should tell us alternative remedy of approaching NGT. Why are you coming to this court?
No,
that you should tell us.
Well, let's.
NGT has looked it. You answer with reference to case laws. How can you land straightway High Court and then why not under Article 32 before Supreme Court?
Like that.
Right to environment is a healthy environment is a fundamental right.
Article 21 and
21. Therefore,
the sentinel quiver.
No.
Your lordships have got a greater responsibility.
1 minute. Don't tell us about our responsibility. What we are telling you, we are conscious about our responsibilities. We don't need.
Your lordships have said so.
We don't need Mr. Reddy to tell us that, and Mr. Gummi Damodar Reddy and Gummi Narendra Reddy to tell us.
They will never venture.
What are our responsibilities?
They will never venture. Never venture.
Then don't tell us. We are trying to tell you, we are asking you a legal question that why you should not go to NGT, answer that. Because you have not brought anything, case law, nothing. Why you
coming up only for admission,
Therefore, we are asking them to file a status report. Next day,
I leave it there.
Next day, you tell us, we are putting a query to you, sufficient notice to you, study why you should not go to NGT.
Yes.
That doesn't, so you have said that right to healthy environment is fundamental right, then we can tell that for violation of fundamental, take these constructively.
But the reason
now senior counsel said that I will conclude 10 minutes. The provision remains the same. You should have said that I will adopt his submissions and adds whatever he has not argued, if any. You are saying 3 hours.
The point for consideration with this
Nothing, no point.
Different.
No, but validity of rule can be challenged on these 3 grounds in his case also, your case also. It's not that additional 5 grounds in case because he is senior and only 1 ground because you are a junior. Not that. Which case you have filed IA?
Item number, writ petition number 1350.
No, item you don't have the list.
88, my lord.
Fix an early date.
Yes.
Why? What is the urgency?
Lord, now the state has issued, my lord, notification this month.
Don't show fingers. This is again bad manners. If I show fingers like you, will you like it?
No, my lord, I gave papers.
Will you like it if I show? No, don't show fingers for the court. Yes.
That the state, my lord, has issued a notification, my lord, notifying vacancies of 5,000 vacancies in respect of the same post. Again, now, my lord. So there is an urgency because they will follow the same rules. Again, the petitioners will be ineligible for the same post, my lord. There is a
that cause of action is yet to accrue.
I'm sorry.
Cause of action is yet to accrue. This you are saying it should be heard early to avoid possibility of a future litigation.
This same rules are made.
So you will have to, Mr. It is under challenge. What is the effect if you succeed in the writ petition?
I will be eligible for.
No. Effect. Does it apply prospectively, retrospectively? What is the effect? This is not a coaching class going on for. Sorry. Yes. Think about it, what we have said. That if it is struck down, senior counsel.
It would go from the root, goes from the date of its inception, because we have challenged that it's repugnant to the NCT regulation.
So what is the, you are only required to tell us in item 71, what is the urgency? When is the notification issued?
Lord, I have given Millard in the month of August, this month only, Millard, on 20.
No, you don't know, right? We are asking you, you are an officer of the court, you are here to assist us.
Lord, it was given on 25th of August 2023.
No, what is the averments of early hearing application? Why do you want simple question?
Lord,
another notification 25/8/23 issued. 5,000 posts will be filled up. So you will not qualify. What is the submission?
Millard, my respectful submission is, Millard, when the IA was filed in 2018 also, Millard, we were not permitted to write the exam. But now, during the pendency, now the state has issued a fresh notification for the same post, but same rules again being applied, which are challenged before your lordships. Millard, therefore, Millard, I am requesting your lordships to have a early hearing in respect of the challenge to the rules, so that these people can be continuously eligible, because otherwise they'll still continue to be ineligible because the rules are not allowing them to participate in the recruitment process.
What is the age of eligibility? Like age?
Forever
life till. What is your age?
I am 41.
No, not you. Candidates.
Petitioners are very well within the age. But all of them.
That's the question, not your age.
All of them
we are not ascertaining whether you are fit for elevation. You are telling us the age, not this thing. We are asking. There is rules prescribe some eligibility criteria. What is the age of qualification?
Age, my lord, maximum age is 49.
49 years.
Maximum age is 49.
And you are well below 49. Yes. All. You are also like 41. You are also eligible under rules. So you want early hearing.
May please.
No, but what happens 3 hours? We can't give.
I would not, my lord, in my respectful submission, my lord,
I will hear
apologize on that.
Senior counsel has got a first right of audience, being his designated. Thereafter, you will argue only on the grounds not covered by him and give a written synopsis. Correct? Is that clear?
Very well. Very well. Because I'll make my submissions as precise as possible.
No. He will argue first. You will argue on the grounds, legal grounds not covered by him. Right? In 20 minutes. No.
I don't know, my lord, grounds of challenge raised by the senior.
You will hear him.
Very well.
Grounds are only 3, mister.
Very well.
No. What are the grounds of challenge to rules? Any rule for that matter. Forget. What are the rules?
Well, your lordships have already expressed.
No, tell us. We want to hear. He said, you don't know what are the grounds. So we are asking you, what are the grounds on which rule can be challenged? Any legislation can be challenged. What are the 3 primary grounds?
That's in violation of fundamental rights, my lord. It's a first ground, unconstitutional. But also where the state is denuded of power, my lord, and exercising over and above. That in, like central enactment or anything, my lord, it's repugnant. In this case, my lord, we are saying that it's in repugnance to the central enactment.
It can spill over. Yes. Teacher with teacher with age with teachers.
71. Heard on IA number 1 of 2019. Clarity of mind, nothing is this thing. Clarity of mind. 1, 2, 3. These are grounds of challenge. Elaborate. Nothing.
Some of the books we have given, 11th we have given teachers funds. 14th we have given going after. 14th we have given the such as good luck. Which have. Then we have given electricity batch. Electricity batch also we have given. Some data. I do not know. That matter.
Vaidyanathan's. Okay. Vaidyanathan's case was.
CS Vaidyanathan. Santosh, when did we give the date for that, Mr. Vaidyanathan's matter, electricity matter?
I'm not aware, Your Lordship. I'll find out. I'll find out.
Find out and tell us so that we keep a list as to.
Otherwise
I'll just
start fixing the date and in the end. All right.
Just find out and tell the court officer.
100.
Yes. You can have a list of the dates, important dates, what we have.
Yes.
Yes.
May it please your lordships. These batch of matters, my lords, they deal with, some of them are public interest writ petitions. They relate to rehabilitation of women for sex trafficking, children in
This is
conflict.
for admission. We will admit it. It requires.
Formally
Yes.
admit, but your lordships
present.
last time had wanted, there's an order in fact by the division bench requiring both the amicus and me to give a small note.
Where is that? Which
That
order?
note, my side is a little inadequate, my lord, so I'll file it at the next hearing.
All right.
Mr. The amicus as predictive is ready.
What date?
Any day.
No. Which date that order saying that?
This is long ago, my lord, sometime in 2021.
28/7/2021.
28/7.
28/7/2021.
I can pass on a copy of law.
So
it's at the end of the order, my lord. It's a long order. Page 1.
Status report. This State Legal Services Authority was required to file a status
State
report.
has filed its status report.
No, this Legal Services Authority is also directed to file.
No, TSLSA, Malad, has filed later after
Later.
this order. But in fact, Malad, that is not in conformity with the earlier orders which have been referred to. Malad, I'll point out whenever the matter is being taken up.
Mark the presence of everyone. Petitions are admitted for hearing. Yes.
Lordships are fixing a date, man.
Please file some application. We will fix a date.
Gotcha.
Yes. 112, madam.
Your lordships, may it please as your lordships, your lordships, it's
What is the issue?
your lordships, it's regarding non-implementation of section 12(1)(c) of right of children for free and compulsory education, your lordships. We have filed expedite petition, your lordships. During last hearing, your lordships, counsel for respondents informed this honorable court that there is a batch, your lordships. However, there is no batch listed, your lordships.
You are party in person?
No, your lordships.
You are an advocate?
Yes, your lordships.
All right.
Your lordships, earlier, your lordships petitioner herein filed one PIL, your lordships. However, during bifurcation, your lordship, the file has been transferred to.
What's your name, madam? What's your name?
Manasa, your lordships.
Okay, so it mentions Sri Lekha Pujari party in person. So that's why we thought, are you?
Three matters are there, your lordship. Three matters are there, your lordship.
Matters are there, your lordships.
So what? Yes, madam, we will admit it.
Charter is filed.
Your lordships, all the pleadings have been completed, your lordship.
No,
there is an urgency, your lordships.
Madam, this is a public interest litigation.
Yes, your lordships.
If you don't behave like an officer of the court, we can, Sheila Barse, please read, what is your locus? This is just like saying that the state is directed to ensure that provisions of CRPC and IPC are followed. All laws are followed by the state. What is the implementation of 12(1)(c)? Now tell us, what are the figures in respect of state of Telangana? Where are the figures that children have been deprived of their fundamental rights and or the right guaranteed under 12(1)(c)? What are the figures, madam? Tell us.
Your lordships.
This is a vague prayer.
Yes, your lordships. Your lordships, as per
No. Where is the statement showing that these people, in respect of these children, 12(1)(c) has not been implemented? Therefore, petitioner is filing this petition pro bono to seeking implementation.
Your
This is
lordships.
just like seeking a direction to the state to follow provisions of CRPC.
No, your lordships, as per the section 12(1)(c) of right of.
Not 12(1)(c). What we are asking is, in order to file a public interest litigation, you are saying it is not being implemented in all private schools. What is the material you have placed on record to show? Got this material to show that this is the information. These are number of private schools are there. In no school, this 25% rule is being implemented. This is the, I have caused some verification. These are the things which are required for maintaining the pill.
Where are the private schools in the writ petition
We
who
have.
are not giving admissions? Just like madam.
Your lordships may make one submission, your lordships.
Driving inquiry, madam, the bill that is filed like more like a making a roving inquiry without even bringing on record. I have asked for this information. Let us say in Hyderabad there are 1,400 schools.
Your lordships.
So out of 1,400 private schools, how many schools are issuing, complying with this 25% condition? How many schools are not following? And what is the basis for that?
Your lordships.
Can if you are not a party to the petition, can an order be passed against you?
No, your lordships. Your lordships may
No,
make
no.
one submission, your lordships. Your lordships.
If you don't understand, fine. If you are not unable to understand what is told by my brother, fine.
Your lordships, we have filed
We
RTA
will have to
application.
appoint-
So your lordships.
We will
your
appoint
kindly.
somebody as a Micus Curie. You are an
Lordship.
countryman.
Your lordship.
It is a
I make one
publicity interest
submission, your
litigation.
lordships.
Publicity interest litigation, right?
No, your lordships. Your lordships may make one submission, your lordships. Your lordships. Petitioner herein filed WPPIL, your lordships, LDR, your lordships. Your lordship, there is an order. Your lordships kindly Page number 54 to 61, your lordships.
This is not the answer to the query post, madam.
What my lords have asked, did you understand?
Your lordships, as per the law, your lordships are, as per the act, your lordships, state government need to issue notification, your lordships.
Which is your petition? First tell us. Because these are 4 petitions.
The
You are every.
PL number 38 of 2021.
Only one case you are appearing?
Yes, your lordships.
Give 38. Then don't make a representation as if you are appearing in all 4 cases. What is the prayer in the 2 things you answer, madam? If you understand, well and good. Don't understand, orders will follow. You have, listen to us carefully. You have prayed for.
I have prayed.
1 minute.
Your lordships implement.
You have prayed for implementation of section 12C
Yes,
of RTE Act. What is the material pleaded in the petition or placed before this court to show, number 1, that in respect of who are the educational institutions which are violating the right under 12(1)(c. Number 2, where are those educational institutions? The respondents are only 4 in number in your petition. So, third question is whether in the absence of educational institution, whether any effective relief can be granted in a public interest litigation. Answer that. We will come to urgency after you answer.
Your lordships.
What is the data?
Your lordships, we have filed RTI application, your lordships, in page number 99 to 102, your lordships.
There is no data, madam. All right.
103, your lordships.
What can we take? In a public interest litigation, no roving inquiry can be made. Thank you. This is all.
Your lordships.
Yes. Anything else?
Your lordships.
You are answering the question.
We have.
Once my brother has asked, once I have asked, you are not answering the query.
Your lordships.
What is the data to show Mr. Prasad, young person, not able to comprehend the scope of questions? So she has 1 minute. Please explain to her. The communication will be faster. Here it is what is that we are enemies, so she will never understand. We are asking her 2 questions. Mr. Prasad, this is a public interest litigation in which petitioner seeks implementation of section 12(1)(c) of RTE Act 2009. So first question we have asked is, what is the data particular petitioner has to plead to show that in respect of a definite section of people, this 12(1)(c) has been not been implemented, violated. There is no data. She is unable to tell the data, trying to buy time and doing whatever. You have seen her. Second query is, which are the educational institutions who are violating 12(1)(c)? Those you see petition cost title, only 4 respondents. 1, 2, 3, 4. So in the absence of those educational institutions, can we grant any relief in public interest litigation? Third thing is, in a public interest litigation, no roving inquiry can be made. The petitioner is under an obligation to conduct an inquiry and furnish facts and not be involved in a blame game that they are not doing it. It is not an front to fight against the authorities, which she is trying to do. She doesn't seem to understand our queries. Please explain to her in your own way so she understands, and otherwise we pass a note saying that this can't be entertained. That's what Mr. Prasad, we have told.
Mr. Harendra Prasad. In fact, what the petitioner is required to do is at least make some inquiry on her own. Maybe you see in 1400 schools in Hyderabad, she may not be able to collect that information. Some schools she has to make an effort, bring that material on record and also approach the authorities saying, I have caused an inquiry into these things. This is how they are flouting the rule or the provision. That is why I am giving a complaint, and if it is not done, then approach the court.
Indicating to
and Mr. One thing, and those nobody is there.
Yes, nobody.
How roving inquiry can be made?
I was indicating my lords, your lordships.
Tell her, please, so that she understands from you. In the fond hope that she understands what you say. Not successful.
I'll seek time, I request time, your lordships.
And then you said urgent, right? Right now, urgency.
Lordships.
2020, you have filed the petition, forgot about it. 3 academic years are over. Whom do you tell, madam? Think you have to properly study the subject, make available this thing, particulars on which you are claiming relief, implead those persons as parties.
Yes, your lord.
How can just like publicity interest? That's why Supreme Court says publicity interest litigation. And all youngsters appear in PIL. Correct? In this public interest litigation, petitioner has prayed for the following relief: quote 1 and 2. However, it is, however, when a query was put to learned counsel for the petitioner to substantiate by the material, the reliefs as prayed for by the
May I please, your lordships?
yes, Mr. Oh, back from Supreme Court, right?
My lord.
Mr. Rao. Arey, lighter vein. It's good to see you smiling. Huh? Lighter vein. You see, on remand from Supreme Court. Okay?
Lord,
It's the same case.
Caption need not be, my lord. It's not a remand, my lord. Simply, I was asked to, Lord, make an request, my lord. It is actually not a caption, my lord, and the remand. My lord, now your lordships directed the university, my lord. These are medical officers, my lord. Sir,
Mr. Rao.
They were asked to be treated, my
Mr.
lord,
Rao.
as local candidates, my lord.
Mr. Rao, their order was 22/8/23. It's a matter where we have received it on remand from Supreme Court. 22/8/23, we had passed an order, right?
But they are not the local candidates. They studied outside the country.
No. So
they are claiming
what do you say?
They are claiming your reservation under in-service category.
No. So you filed counter, etc. Counter to the main petition and the IA.
Not where the additional counter affidavit is prepared.
When you want to file count.
Yes.
Today's matter, your lordships, my lord, the pronouncement matter, my lord, judgment matter, lordships allowed other candidates, my lord, in the same terms. 4.1b covers, my lord, the petitioners, my lord. both study and residence, my lord. Residence if considered because they have already uploaded residence certificates.
Last one, kindly say local candidate is one.
No, Mr. We are, Mr. Now you are ready in on the this thing. We will hear on interim arrangement if you are ready. You want to? Yes, Mr. Rao.
Last one, put it tomorrow.
Mr. Council, tomorrow?
My lord.
Why do you want tomorrow?
But I file additional counter because they studied in
Mr. Rao,
outside.
Learning
Last week.
Council for the university, prays for short accommodation to enable him to file an additional counter to IA filed by the petitioner seeking interim arrangement. Let the petition be.
Serving a copy on him, so that we take them after tomorrow.
So, Mr. Day after tomorrow is fine because he shall, brother is suggesting that he shall serve a copy on you tomorrow, Mr. Rao.
Yes.
And then you can, we will put it day after.
Yes.
Correct?
Day after.
Mark the, this thing, his presence. Learned Counsel for the petitioner submits that the matter has not been remitted by Honorable Supreme Court, right? Not been remitted by Honorable Supreme Court. Therefore, the office is directed not to list the matter under the caption on remand from Supreme Court, inverted commas. Mr. Prabhakar Rao, Learned Counsel, states that the university shall file a counter by tomorrow after supplying a copy of the same to Learned Counsel for the petitioner. List on 31st of August 23 for consideration of prayer for interim relief. Interim arrangement.
Additional counter.
Additional counter, right? Final hearing. Good. They also we have some time. Yes.
But I'm for the respond number 2 to 4.
What is it, Mr.?
What?
See, he is reading now. Ask him, he is reading now.
This is rejecting the application, Milan.
No, we are ready.
Of course, he has to be ready.
Sir,
No,
he is for the respondent. I am for the respondent.
No, we will decide. We asked you what is the matter about, you didn't answer. Started reading, so we got an impression that you are preparing the case right away. So burden is on us only to decide. In the absence. Fine. 1 minute.
For granting the mining lease, Miller.
Not a period. Dismiss dismiss every other case. Their option will decide on that. So, grant of lease can be put to the registered yes to file a review to fit simple summons under NPR. 91st Supreme Court has said while this petition has been rejected and dismissed, whatever. But we don't allow. See.
Before.
This is against an order passed in which petition? And There are other connected read petitions also. What happened to that? This is 771. And there was a read petition also. 1996.
1996.
So other connected is that line. Other, maybe this.
This is different.
What happened? Can you find out?
Yes. What happened to the other writ petition, connected matter? 1996 of 2001.
That what, no knowledge similar that for me.
See, this is a writ petition number arising from writ petition order in WP number 771 of 2001.
Yes, my lord, I have announced status me.
The moment we ask you a question, you will seek adjournment, right?
No,
That's
not
the difficult.
that I have no knowledge about the other writ petition, my lord.
See. One to mining list. This one in the section 30 of NMB are actually revised and 95 Supreme Court total fee. Supreme Court the article of the could be my question setting aside. We'll set aside the short. You will not argue. It's a query please. Not mining please. Query please. Really? And the minor mill. Gray granite. Big the minor mill. Not a major mill.
Is it a major mineral or minor mineral?
Miller?
This grey granite is a major mineral or a minor? Minor.
And that to Telangana rules. That what?
Minerals. Minor mineral, major mineral. She was given hypopoles. MMRD acting.
లేదా No. Which one?
Order deleting the excess area of 1.33 hectares, whether it was passed after affording an opportunity of hearing to the petitioner or without hearing.
Giving the opportunity, my lord, and also explanation is.
No, this learned single judge has recorded a finding he is not heard. It is incorrect.
Millard, one comes.
He's what, say, they have filed an appeal. Noble Marbles. And.
After explanation, Millard.
No, but what? 771. Srisha Geo. He is Noble Mineral. Respond number 4. Right. They have not filed an appeal.
No, straight or no.
So you have accepted the order passed by learned single judge, right?
Yes.
Then why are you arguing on behalf of respondent number 4 in this petition? You should say that correct. You should have you implemented this?
Millard,
And
there is
you have been, Mr. Respond number 2 in the petition has been directed to invite applications for grant of prospect license. You invite application, fresh application and grant it.
Millard, there is amendment, Millard, GO number 26. Kindly see the GO number 26.
No. Arey, Mr. You cannot be permitted to assail the order passed by learned single judge. You are not the appellant, right?
No.
We don't.
You are supporting the case of the appellant or the learned single judge?
Or the petitioner in WP.
No. Please tell us your stand. You are supporting the order. Respondent number 4, Millard. I am supporting. Who is now appellant? Respondent number 4 is the appellant. Yes, I am supporting. You are appearing for the respondent number 2 to 1 to 3 Millard. That is state government. Yes, state government. So the learned single judge passed an order directing you to do certain things. Yes. You are not coming appeal. So to that extent, the order you have accepted. Have you implemented the order is our question. No, already implemented, Millard. There already there is a renewal of the who is the respondent number 4 is now renewal already extended. Please extend it, Millard. As per the but the learned single judge held that to the extent of exclusion of 1 hectare 13 hectares or whatever extent of mine is without notice to the petitioner. Therefore, the order the exclusion is wrong. That is the order. Already here, non-arts Millard already giving notice to the petitioner and thereafter deleted the excess area, Millard. Kindly see. Why we are asking, have you implemented the order of the learned single judge? Millard, there is a already amendment, Millard, in this. GO 26. But rule, Millard, rule 12(1) is the replace as follows, Millard. Kindly see the rule 12 of the Minor Minerals Act, Millard. The minor mineral concession except water.
When? 31st March 2020.
Yes, 22.
No. So you are not required to invite application under amended provision. You can secretly grant it to the appellant.
No, Millard. This is the Millard. These amendments.
It has no bearing.
Come into force. 2022.
It has come into force. The only order says that consider and decide the application in accordance with rule 12(5) of the rules. You do it. 12(5) of the rules is subsisting rules only. As amended. That's the only thing you want. It will be done.
Open auction, only for open auction. So, reading applications, open auction. This 26, rule 26.
Which provision?
Millard can rule 12, Millard. Rule 12 sub rule 1 shall be replaced as
rule.
The mineral concession.
Rule, which rule?
Rule 12, Millard. Amended in the GO number.
So you follow the procedure prescribed under amended rules.
Yes.
Correct. This is what is so be amended. Neither except ordinary and granted the auction. We would say that in accordance with 12 as amended by 31.
Every earlier is subsisting or
Excess area it has been set aside.
It's 1.3.
It is only one, they will take action on the 12-1.
Appellant's counsel expired. V. Rajgopal.
Today, after a long time, you got a right.
Sorry. Sorry, suddenly.
Who expired?
V. Rajgopal. Preeti's father.
What is done normally in such a case, Mr.
Notice to be ordered to the appellants.
Yes, madam. None for
Only in the Vakala, there is somebody else.
1 second. Let us, 1 second.
Vakala, somebody else.
none for the appellant. Or whatever he is for. You are GP or what?
Fines and geology.
GP.
So that you don't have to, we don't have to change it.
Yes. Yes. 118.
I beg to represent Mr. Vivian Narasimha, my lord.
Yes.
My lord, this writ appeal file is filed, my lord, against the order and order of the learned second judge.
What?
My lord, this writ appeal is preferred against the order of the learned single judge in WP number 15728 of 2006, whereby the learned single judge dismissed the writ petition filed by the petitioners, my lord. The fact is that, my lord, there is a land of an extent of 100 square yards situated on the rear side of the petitioner's residence, my lord. In 1992, the Housing Board proposed to conduct public auction, my lord. The participants, may I audible, my lord?
Yes, go ahead, Mr. We are hearing you.
My lord, I am Rajeshwar Rao, my lord, representing VVS and VVS.
Please. Yes, Mr. Rajeshwar Rao. Please go ahead.
My lord, my lord. Originally, the writ petition is filed, my lord, questioning the action of the respondent is not considering the representations of the petitioners, my lord. The facts are like this, my lord. An extent of 1,000 square yards are on the rear side of the petitioner's residence, my lord. In 1992, the Housing Board proposed to conduct public auction, my lord. The participants in the public auction offered only 5,000 rupees per square yard. That public auction was not confirmed by the Housing Board, my lord. Thereafter, the petitioners made a representation to the Housing Board. Thereafter, after considering the representations, and nobody is coming forward to purchase the land, my lord, the Housing Board addressed a letter to the Principal Secretary, which is at page number 21, my lord. After calling for the petitioners for the deliberations, my lord. After due deliberations, the Housing Board came to the conclusion that though the market value of the market value at that time is 6,000 rupees, the Housing Board was fixed rupees 5,000 rupees per square yard, my lord. And the Housing Board addressed a letter to the Principal Secretary Housing Department dated 30/11/2000, which is page number 21, my lord. Based on this letter, my lord, the government issued GOMS number 206 dated 27/8/2001, which is at page number 20, my lord. May I read, my lord?
You read page 5 of the order of learned single judge
My lord.
with reference to submissions.
My lord, the learned single judge came to the conclusion that the GOMS number, which enumerates that, my lord, if the land is more than 100 square yards, public auction has to be conducted, my lord.
So they conducted a public auction. You were asked to, you paid only 10% of the amount. Thereafter, the grant of time did not pay the balance amount.
My lord, because of the
And therefore,
my lord, because of the interim orders passed in WP number 198.
therefore, no direction can be given sale of property in contravention of GO dated 27/8/2020 2001.
My lord, that is,
We can't issue a writ of mandamus and there is no prayer. There is only for decision of representation. That's all.
my lord, yes, that is correct, my lord. Because of the interim orders, no finalization was done by the Housing Board, my lord. And the GO issued by the government of the erstwhile Andhra Pradesh, which states that in relaxation of the GO issued under in GOMS number 38, my lord.
All the trends are more than.
Yes.
My lord, your lordship may kindly see the GO, my lord.
No, no, Mr. All lands are more than 100 square yards, correct?
1,000 square yards is correct, my lord, but different.
More than 100. More than 100.
More than 100, my lord.
Then
But
they have to be sold by an auction only. What else?
yes, my lord.
You have not challenged GOMS. Mr. You have not challenged GOMS.
206.
206.
I to admit, my lord, because the exemption.
That's the end of the matter.
Government.
End of the matter.
My lord, the GO itself says that in relaxation of the GOMS number 38, they have allotted the land to the petitioners, my lord. That is my respectful submission before your lordship.
No, allotted the land, fine, but that doesn't mean free of cost.
No,
You didn't pay anything despite extension.
Cost, my lord. I am ready to pay the whatever the market value prevailing as on that date. I am ready to pay, my lord.
Purchase it in an auction. Purchase it in an auction. Purchase. Nobody prevents you from purchasing it in an auction.
But my lord, I am admitting, my lord, because nobody is participating in the public auction. They went for selling of the land, my lord. The housing board itself offered 5,000 rupees per square yard and requested the government to issue a GO.
Mr. You don't pay the amount, what can be done? We cannot pay, High Court cannot pay balance amount for you. Correct.
Because I am.
Mr. You go to the housing board, do whatever you want to deposit it for housing board. Last paragraph of the order we asked you to read.
Pardon,
Last paragraph of the order, page 5, again read it for our benefit because we have not read it. You have read it, please read.
In reply to paragraph, sorry, I'm sorry.
With reference to submissions.
I'm sorry, 1 minute.
Page 5, with reference to submissions.
With reference to submissions made by the land council for the petitioner, in this case, it is to be seen that according to the petitioners, the said piece of land which is adjoining the houses of the petitioners is about 965 square yards. But however, in the counter affidavit, it is stated that the said land measuring 1,214 square. Though on earlier occasion when the respondent board sought permission in favor of the petitioners at the rate of 5,000 rupees per square yard. But however, the petitioner did not pay the said amount at the rate as fixed by the government pursuant to the communication sent by the respondent board. Though the petitioners have paid partial consideration, but they did not pay the balance amount even in the extended period of time during the year 2001. It is stated in the counter affidavit that the amount paid by the petitioner was refunded to them, even as per Rule 29 of the AP Housing Board Rules 1959, framed under the AP Housing Board Act 1956. Disposal of the property of the board by sale or lease shall be by public auction. In that view of the matter, and as the petitioners themselves failed to pay the amount fixed in GORT number 206 dated 27/8/2001, no direction can be given for sale of the said land. In that view of the matter, I do not find any valid ground for grant of relief as paid for. My lords may kindly see the para number 20.
So did you pay the amount? Is it your case that you paid the balance amount?
My lords may kindly see
Was it not,
our request.
Mr. Two things, you did not pay the balance amount within the time limit. That amount was refunded to you. End of the matter.
Yes, correct. Because of the stay granted by this honorable court in WP number 198 of 198/65 of 2001, our request was not considered, and I filed an application on 25/2/2006, my lord, which is at page number 23. In this connection, we have to state that we are ready to pay the balance land cost as the writ petition.
Mr. Counsel, Mr. Rao, we will advise you not to invite an order by this court. We are ready to pass. You will get in next 10 minutes. But what we say that if you are ready and willing to pay the market value of the land, approach the housing board.
I have approached the housing board.
No. Fine. Then if you want us to decide, we will decide. We are suggesting you don't ask this court to adjudicate, because then their only option will be left is 136, Article 136. It's better we are suggesting that you approach the housing board with whatever you are offer and let them decide. Instead of seeking a stamp of approval, if you want to, we will pass an order right away, subject to what you argue.
I'm not saying that, but I'm apologizing, my lord, because
No apology, Mr. Why? There's no apology. It's a suggestion from the court. We will hear you, whatever you have to argue. Yes. So.
Because according to the counter affidavit, my lord, I filed a representations to the housing board on 25/2/2006 itself, my lord. Because of the stay granted by this honorable court in another writ petition, the sale was not confirmed by the housing board, my lord, government, my lord. Therefore,
Which order of stay? Where is that order of stay?
that is that order is not there, my lord, because
I
have
not there.
order.
You did not bring it to the even Mr. Notice of learned single judge. You are arguing in an intra-court appeal without bringing it on record. Note of oral submission.
Your lordship may kindly grant two days time, my lord. I will come with the
No time. 2008, 15 years. Still we are, Mr. Rao, still we are telling you better to go to housing board with your offer that you are willing to pay the market value. Housing board will decide. Or you want an order on merits, we will pass an order on merits. There is no subsisting right in you claim that it should be allotted to you only.
My lord. Because after the disposal of this writ petition, my lord, I filed an application.
Not getting it. What?
My lord.
If
we adjudicate, then once for all, your this thing will be sealed with housing board. We'll have to only hold that it can only be sold by public auction because the extent is more than 100 square yards.
Yes, my lord.
So if we follow strictly GO 206, it cannot be given to you. It can only be by way of a public auction. For that reason, we are suggesting you approach the government, the housing board, with make some valid, genuine offer. Maybe they will consider. If you want adjudication, we will simply have to confirm. Then they will not even look at you. Thereafter, you will not be able to climb the steps of housing board.
My humble submission before your lordship is, my lord.
No, Mr. Rajesh Rao, let us be one thing clear that 5,000 cannot be accepted now. Much water has flown, 22 years has flown.
I don't see, my lord, that now the
So that
present
is why we are
market
saying
is high.
don't harp on the 2001 rate of 5,000.
That's gone over.
Yards.
He has received the refund. Anything else, Mr. Rao? Anything else?
My only submission.
You told us two submissions that there is after you had submitted a representation to the housing board and there was an order of stay in some writ petition. Because of that, the representation could not be considered. Anything else?
My humble submission before your lordship meeting. GOMS number 38, which was earlier issued by the government of Andhra Pradesh, by relaxing that judgment, the allotment was sales were made. That is only my submission before your lordship.
All right. Which GOMS?
GOMS number, which is there in the GO.
Where is the which page of the paper book?
20, my lord. Page number 20, my lord. May I permittably read, my lord? May I read, my lord?
No, we have read it, page 20. So what is GOMS? So what is the submission? We have read it, Mr.
My lord, in the last line, my lord, in relaxation of the GOMS number 38, my lord. Last but two lines, my lord. In the circumstances reported by the Vice Chairman and Housing Commissioner AP Housing Board in his letters read above, government after careful consideration hereby permit the Vice Chairman and Housing Commissioner AP Housing Board to sell the land available on rear side of the house bearing number so and so Amirpet to the adjacent house owners at the rate of 5,000 per square yard and also shown below, subject to the withdrawal of court cases pending in the court and also in relaxation of the orders issued in GOMS number 38.
Fine. So therefore this, at the rate of 5,000 rupees, it should be granted to you right away. This is the argument.
I am not asking, my lord. The prevailing market as on today, my lord, we are ready to purchase the same.
All right. Mark the presence. This intra-court appeal is filed against an order dated 8th of October 2007 passed by learned single judge by which writ petition preferred
I have not, though the check was issued and refunded, the check was returned to the housing board, my lord. The amount is lying with the housing board, my lord. Your lordship may direct the housing board to pay the amount, my lord, with interest.
You can go and approach it.
Approach, and housing board didn't say, this is not a prayer for refund. Yes, rate appeal, yes.
What we are taking is something just any person would have refunded. Like it's like what we were taking that we will be going. Instead of what we do.
How difficult?
I beg to represent M. Ramarao, Milan. I beg to represent M. Ramarao. He instructed me to take adjustment as the compromise talks are going on.
But I've taken
See,
instructions.
his
from my-
smile on his face tells that this statement is
My
incorrect.
instructing counsel tells me, Malad, there is no such instruction, Malad. That's what I told him also.
Go ahead. Go ahead.
Lord, I'm not his office, Milord.
Don't appear then. Don't appear. Yes, Mr. Senior Counsel. Please.
Yes,
Sit down.
and single judge, Malad.
You
this is
can
a
go,
case-
Mr. You are not concerned with the case. Please leave the court. I mean, what we are saying is that you can sit here, and watch what is the order and convey to your friend, but you can leave also if you want to. The choice is with you. It's a public place, we cannot say. You want to observe the proceeding, right, and to communicate what order has been passed. Supposing if it is allowed, you will say that, no, mark my presence. No, you will not say, right? Even if this appeal is allowed, you will not say that mark my presence.
My instructions are like that.
No, nothing, no instructions. We are not bound by those instructions. He has controverted it.
No, Malad, my instructing counsel.
speak.
Malad,
We are not saying he is saying in your presence. You tell him. We are not adjourning old matters. Don't take this onerous task of seeking an adjournment, which is nearly an impossibility in this court. Yes.
Let me give the facts, Malad, in brief. Malad, there was a provision, section 5, capital A, Malad, in 1971 Act, regularizing Malad unregistered sales. But there was a provision, Malad, because that has been now repealed. So 5A, Malad, in 1971 Act provides for Malad regularization of unregistered sales, Malad. So we had applied for, respondents herein, Malad, have applied for, and Malad got the certificate, Malad, of regularization. That was challenged, not by the party, Malad, who sold it to us, but another person, Malad, his own brother, claiming himself to the agreement holder. So he filed the appeal. We challenged, Malad, appeal was also provided in section 5B. Malad, we challenged Malad in the appeal saying that you have no locus standi to challenge. Original owner has not challenged. He was the party. He has not challenged it. Then Malad, the appellate authority has not decided that issue of the locus standi, Malad, of the appellate to challenge the order. But when we last Malad appeal on merits, Malad, he has gone into the merits without deciding the issue of the locus standi. We filed the revision. Before the revisional authority also specifically this ground has been raised about the locus standi. Revisional authority under section 9 has also not gone into this. But the revision also dismissed. We filed the writ petition. But when it came up before the learned single judge, looked into these aspects, saying that before the original appellate authority and as well as the revisional authority, we raised the issue and as it has not been decided.
Order of remand.
Order of remand. But only thing I need to tell you, Lordships, now 71 Act has been repealed. 2020 Act doesn't have the similar provision. But it has got section 16 of the repealing 2020 Act says the pending disputes will be transferred. But it may not be strictly, it may not be pending, but and the writ appeal and the stay. But it would have been pending before the RDO. There is no such jurisdiction which has been given to the appellate. No appeal is provided. No 5A also. No regularization also now in
the proceeding under 71 Act would continue, right?
That's how, my lord, under section 16, there is a special tribunal. Special tribunal, my lord, can be asked to decide the issue.
Yes, yes.
On report.
Correct.
Special tribunal has been defined.
Yes. Yes, madam, right. Lordship. So you will have to record his submits which is refuted, therefore we proceed to, then he said, I have no instruction to argue. Then we are deciding. Peruse the record. What's your name, Mr.?
R. Shamsundar. R. Shamsundar, Honorable Council.
Statement comes separate.
Separate. Sri Shamsundar, Honorable Council representing Sri M. Ramarao, Council for the petition. And Sri Chidu Prakash Reddy, Leonard Senior Counsel appearing on behalf of one council for the response. Orders, orders of white applicant. Order వచ్చేసి writ appeal. This intra-court appeal is preferred against the order dated 4th November 2008. Passed by the single judge of the court in writ petition number 1038 of 2022, whereby the challenge in the whereby the relief sought for by the petitioner to call for the records relating to proceedings of the first respondent in file number so and so dated 24/11/2001 have been remitted back to the second respondent for de novo consideration, including the objection raised by the petitioners on the locus standi of the responding number 4 to maintain the appeal. Full stop. We deal with facts giving rise to the filing of the present appeal. Agreed by the said order, the present appeal is filed by the petitioners. No, filed by the respondent. Respondent number 4. Full stop. The facts giving rise to the present appeal are that the petitioners in the writ petition claiming to have purchased the land claiming to have purchased land at measuring 3 acres 17 guntas in survey number 241 to 243, 263 and 274 of Amangal Hayatnagar village and Mandal Rangareddy district.
Yes, it is.
You are appearing, madam?
I intend to appear for all the appellants, Loves, Murthy's proposal. Also, your third appellant number 1, D. Swami, is dead. Have to file the appropriate SR petition and take steps.
Appellant number? 1. 1. So you are representing, right? What's your name, madam? Write her name. Office is directed to delete the name of Shri VLNG K Murthy and instead to print the name of madam. Print the name of so and so. Learned counsel for the appellant submits that the appellant number 1 has expired. She therefore praise fund is granted a week's time. 2 weeks time to enable her to move an application seeking substitution of LRs of diseased appellant number 1.
The appeal is directed to be posted along with the contempt case 1577 of 2014.
Which? Yes. In view of order dated 20th April 2022, post this matter along with CC number 1577/2014. Yes, madam, 121.
May I please? My senior is out of station, kindly.
No, you are in station, right? Most auspicious time to begin your career.
But my senior is.
No, you should you should always tell your senior, I told out of station, but what to do? Judges were so unreasonable that they did not grant adjournment and made me argue. Best thing. What is it about? You will have to tell us something.
But the writ appeal not filed against the order of a single judge. But confirming not the blacklisting the petitioners from not on the ground he has not.
For a period of how many years?
There is no period is not specified.
Oh, lifelong.
Yes. And also forfeiting the 2,50,000 which was paid towards EMD amount. Blood. There was interim order permitting the petitioner to participate in subsequent tenders. Blood.
Misconceived. The learned single judge did not blacklist you.
Order in the review inspections. That was confirmed in the by the learned single judge. Single judge. But impugned order in the
No. So we will clarify that this blacklisting was only in respect of that tender dated 26/5/2005, and thereafter you have been permitted to participate.
Yes.
So that has obliterated, right? Nothing survives.
Not so far as nothing.
No, you are not blacklisted for a period or anything except this tender.
Correct. It is not time. Which is the order blacklisting?
Page 27 of the
27.
Page 27. This page 29 is operative portion at paragraph 20.
Yes. You have prepared the case so well, Mr. Why were you seeking an adjournment? You have prepared it so well. Yes.
Page 29.
29. Where is the
last paragraph? Further, we say Kaim is hereby blacklisted and prohibited from participating in any tender of the corporation in future.
It can't be forever.
Yes.
Correct. Where is this clause, Mr.? Which clause? Clause 29 of the tender.
Page 35, not is a tender condition paragraph. Class number 29.
See. Yes. So, High Court, Honorable High Court in WP number 8086.
Yes.
Where is that?
I'm sorry, but that order is not filed.
Madam, can you get this order? 8086 of 95.
But that is filed in another item number 121.
121.
Yes.
Madam, give the file of 121. Which?
Page 15.
1 second, give Sundaresh, 1 second. We are taking the other bundle, next bundle.
122, madam.
Sorry, 122.
Page?
Page 23.
Page 15.
Wait. Very good.
15 to 24 is the order.
Unnumbered paragraph 2. Unnumbered paragraph. I may permit to.
Wait, this is only for that year, Mr. You were first, exclude, you were second respondent in the petition.
My lord.
You were second respondent in the writ petition.
This repetition, they said that, they only said that, in favor of her, which is.
What is you, who are you? What's your name?
But I am in my name.
Something else. You are not party to
Yeah, I'm
this
not a party to the writ petition. Page 25, I'm not a party.
but see, what they have done is blacklisted in furtherance of this order. Still not a party, how can?
They can do blacklisting for lifelong.
Lifelong. Correct. You tell your senior that the court has told that I argued so well that both the petitions are allowed. What's your name?
My name is G. Sundaresh.
Sundaresh.
G.
G.
Mr. G. Sundaresh. None for respondent. Nothing. No adjournment.
No
In
adjournment.
this rate petition,
Another condition is not forfeiting 2,50,000 rupees, which was paid towards EMD. Not, that is also not.
That can't come.
We will question this thing. In this writ petition, the petitioner has filed, petitioner has questioned the validity. Oh, single judge.
Petition.
Which is the order? This intra-court appeal, delete. This intra-court appeal emanates from an order dated 23/9/2008 passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Full stop. The parties in this for the purposes of this order, parties shall be referred to as their rankings before the in the writ petition, not in the writ petition paragraph. The Andhra Pradesh State Civil Supplies Corporation Limited, within bracket herein after referred to as the corporation. Correct, madam? Invited tenders on 25/6/2005 for transportation of food grains, pulses and other essential commodities from various places within the district and outside the district to various places within the district. Full stop. The contract was for a period from 1/8/2005 to 31/7/2006. The tenders were required to deposit a sum of rupees 2,50,000 by way of earnest money deposit. Full stop. Earnest money deposit. Full stop. Clause 16 of the NIT provides that that a successful tenderer has to enter into an agreement within 3 days by making payment of security deposit of rupees 8 lakhs after adjustment of the earnest money amount of earnest money deposit. Full stop. Clause 29 of the NIT stipulated that a tenderer who fails to fulfill the tender conditions at any stage after acceptance shall be disqualified and blacklisted, in addition to forfeiture of EMD and security deposit. Paragraph. The petitioner submitted his tender for Hyderabad district and quoted a rate of rupees 10 metric ton per kilometer for first 16 kilometers and rupees 10 per metric ton beyond 16 kilometers. Full stop. The petitioner thereafter submitted a representation that the rates quoted by him should be considered as rupees 200 per metric ton per kilometer up to 16 kilometers instead of No senior. You have become senior now. Right? This is how you grow in the profession, Mr. Always very good. We appreciate that you were prepared with the case. Don't take, because court may not grant adjournment, right? Senior is out of station. Let him be out of station. Chaplo.